Hmm. Yes. Bye. Okay, we'll see. We'll try your luck. Okay. Seven, not possible. 2011 back. Mr. Dasgupta is there. Ask him to be present. It is who has died? Huh? B. Prasad. Unnecessary. Ask Mr. Dasgupta to be present. This is a matter which has been heard at length. We are only on one specific question out there as to how it is to be jailed out. Okay? I've already heard your petition, if I'm not necessary. Yes. Mention it before court number 5. Number 1. Yes, Mr. Chaudhary, what is this matter about? Board of Revenue. Where is the order? You are? What's your name? Rosen Lloyd. Yes. There's a sale deed. So that a sale deed has been put to challenge by them in a suit, being title suit number 5/2012. So that is pending. Okay. So you got your mutation done initially.
After passage of the land, it was done in my table. And thereafter, they have challenged. We have challenged the order before the deputy commissioner and the commissioner, the SIT order of this. And then I came to the board of the order was passed collecting motions. When the appeal was moved, on the very day the order was set.
Which one? By the deputy commissioner.
The order passed by the.
Let us see that order.
That order I have to select.
Why haven't you not enclosed? Records are there, no? Let us see that order. Where is that order?
Board is the order. Out of the sense. That order was on.
Yes. No, I've read it. No, Mr. Dhar. There is a sale deed in his favor. Rightly or wrongly, maybe a void sale deed, whatever may be. But that is subject matter of adjudication before the civil court. The revenue authority cannot decide on the said sale. Now, on the basis of the said sale deed, rightly or wrongly, the title has already been transferred to him. There's no quarrel with that. The fact that he is in possession is also not in question. So the mutation has to be there. The only thing this court will do from here, that the mutation so granted in favor of the appellant hearing or the petitioner hearing shall be subject to the outcome of the suit. That's all. That's all, nothing else. Whatever may be, but Mr. Dhar, all these things can't be decided by neither by this court, neither by the revenue board. So the setting aside of the mutation by the additional deputy commissioner, which has been upheld by the first appeal by the Assam Board of Revenue, would not be proper unless and until there. But here at present, he will be only no control right will be conferred upon him. A mutation does not confer any right, so that I'll make it delivered in it. The instant petition has been filed by the petitioner challenging the judgment dated 25/6/2014 passed by the Assam Board of Revenue learned Assam Board of Revenue, in appeal number one, in a revenue appeal number 156 bracket NL oblique 2012, whereby the appeal filed by the petitioner was dismissed. And whereby the appeal filed by the petitioner challenging the order dated 19/10/2012 passed by the Additional Deputy Commissioner Nalbari was dismissed. From a perusal of the materials on record, from a perusal of the materials on record, it transpires that the petitioner herein claims that he had purchased a plot of land measuring how much? 2 kathas, covered by dark number 144, included in NK Patta number 25 of village Khorzana under Khorzara, under Patta Muza in the district of Nalbari. The said purchase was made on the basis of a registered deed of sale bearing deed number, where is that? 371. Why have you not enclosed all these things, Mr. Chaudhary? Are you saving the environment by not enclosing all these things? Why? You have not enclosed the sale deed, you have not enclosed the Additional Deputy Commissioner's order. Why? There has to be some good reasons for that. This is not how you prepare your petitions. By the sale deed bearing deed number. Very. (371/2011). Dated you have not mentioned a single word also that you on when did you purchase. 28/2011. On the basis of the same deed of sale, the petitioner was granted mutation by an order dated 3/2/2012, passed in Miss Case number 7/2012 by the Circle Officer Nalbari. The record further shows that the respondent number 5 thereupon filed an appeal before the Additional Deputy Commissioner Nalbari, being Revenue Appeal number 49/2011-12, challenging the order dated 3/2/2012, passed by the Circle Officer Nalbari in Miss Case number 7/2011-12. The learned Additional Deputy Commissioner Nalbari passed an order on 28/2/2012 to cancel the mutation granted in favor of the petitioner, and directed the Circle Officer Nalbari to restore the mutation of the respondent number 5 in respect to the land by way of correction. This order was put to challenge by the petitioner in revenue appeal being case number 18 RA bracket NL oblique 2012 before the Assam Board of Revenue, and by an order dated 12/3/2012. The order passed by the Additional Deputy Commissioner dated 28/2/2012 was set aside with a direction that the order of the circle officer, that is a part of the Additional Deputy Commissioner setting aside the order, shall not be given effect to. It was also directed by the Learned Board of Revenue in its order dated 12/3/2012 that the order of the circle officer, which was also challenged in the revenue appeal, case number 49/2011-12, also would be stayed pending disposal of the appeal before the Learned Additional Deputy Commissioner. Subsequent thereto, the Learned Additional Deputy Commissioner passed an order dated 19/10/2012, thereby allowing the appeal of the respondent number 5. The petitioner thereupon, being aggrieved, had again approached this court, had approached the Learned Assam Board of Revenue by filing an appeal, which was registered and numbered as Revenue Appeal number 156 RA bracket NL oblique 2012. The record further shows that the said appeal filed by the petitioner was dismissed by the order dated 25/6 by the judgment dated 25/6/2014 by the Learned Assam Board of Revenue, which is the subject matter of challenge before this court. The record further reveals, I've heard the learned counsels for the parties, as well as I have perused the materials on record, including the records pertaining to case number 156 RA bracket NL oblique 2012. From the records, it is seen that rightly or wrongly, there is a registered deed of sale bearing number 371/2011, dated 28/2011, in favor of the petitioner. There is also no denial of the fact that the petitioner is not in possession of the land in question. Under such circumstances, by virtue of that same deed of sale, the right over the land stood transferred upon the petitioner by operation of law, as well as the same deed of sale, subject to cancellation of the said deed of sale in the manner provided under law. The record further shows that there is a suit filed by the respondent number 5 challenging the said deed of sale, which have been registered and numbered as title suit number 05/2012, which is presently pending before the court of the civil judge Nalbari.
Numbered as 71 of 22.
As title suit number 05/2012, pending before the court of the civil judge at Nalbari, and presently renumbered as title suit number 71, and pending before earlier I got to be the court of the junior.
Earlier it was before the civil judge, but after amendment.
It will be before Munsif now. That is what. Nowadays we don't have the Munsif or junior revision. Huh? And presently pending, presently renumbered as title suit number so and so, and pending before the court of the Munsif number 1 at Nalbari. The fact that the said deed of sale has been challenged on various grounds of fraud cannot divest the title of the petitioner till such time the said deed of sale is not cancelled in accordance with the law by a decree of the court. Now, coming back to the facts involved in the instant case, it would be seen that both the orders passed by the additional deputy commissioner dated 19/10/2011, 12, in revenue appeal number 49/2011-12, as well as the judgment dated 25/6/2014 passed in revenue appeal number 156 NL/2012, shows that both the authorities had presumed that the said deed of sale executed in favor of the petitioner is bad in law, and as such have set aside the mutation made in favor of the petitioner. This aspect of the matter, the said assumption by the revenue authorities in the opinion of this court is misconceived in as much as already stated here in above, by virtue of the said deed of sale bearing deed number 371/2011, dated 28/2011, the rights in respect to the land in question to transfer in favor of the petitioner. This court further finds it relevant at this stage to take note of the submission by Mr. A. Dhar, the learned counsel appearing on behalf of the petitioner, who submits that the observations so made in the instant petition, in the instant judgment, should not affect the petitioner or the respondents in the suit filed with suit pending before the civil courts, wherein the said deed of sale bearing deed number 371/2011 has been essayed. In the opinion of the court, the said submission is a fair submission. Next. In view of the above analysis, this court therefore sets aside the judgment dated 25/6/2014, passed in revenue appeal number 156/2011, bracket NL/2012 by the learned Assam Board of Revenue, as well as the order dated 19/10/2012 passed by the Additional Deputy Commissioner in Revenue Appeal number 49/2011-12, and thereby restores the order dated 3/2/2012 passed in Miss Case number 7/2011 by the Circle Officer Nalbari. It is made clear that the order and restore. It is made clear that the said restoring of the order dated 3/2/2012 passed in Miss Case number 7/2011 shall be subject to the outcome of title suit number so and so 75 of so and so. This court further finds it relevant to observe that mutation does not confer any title, and the mutation is done by the revenue authorities only for the purpose of collection of revenue, and as such the said mutation done in favor of the petitioner shall not affect the adjudication of the suit pending before the court of the municip in title suit number so and so. Next, this court further is of the opinion, this court further observes and clarifies that the observations made herein above as regards the rights of the petitioner on the basis of the deed of sale bearing deed number 371 of so and so shall not affect the adjudication of the suit being title suit number so and so pending before the municip so and so. And the learned trial court is directed to adjudicate the matter on the basis of the materials available on record and not to be influenced by the observations made herein. And return the registry is directed to forfeit, return the NCA.
Supplementary is about 30/31.
तुम्ही क्या नामातले itu hakim number agor hakim tu क्या we go as per serial. Mr. Nath will wait later on. Let's go by the serial. Or we take it up at 2.
Number 2.
Huh?
On 17/4/2001.
You have not been released till now.
No.
Yes. What do they say? There are lots of affidavits. Why? Shall not issue directing and commanding the respondents to repair and release the vehicle bearing registration number so and so in serviceable condition in terms with the judgment dated. What is this judgment? 18/5/2010.
Is that page method? Page 92.
Page
Right, online.
What election was this?
For general,
Who has filed the on behalf of this?
my lord.
Wait. Is Election Commission a party? Huh? It's not a party. Now, where is the vehicle?
If not, my lord, kindly look into my lord, and inquiry was conducted.
Now, when was your vehicle taken?
My lord, from 17/4/2001.
17/4/2001. Then on requisition. 17/4/2001. Then
Each, my lord, each party.
page 15. 17, no, 16/4. Reported at 17/4. Then
Thereafter, my lord, they are not releasing my salary.
thereafter they have not released. Now, what do they say? They have filed so many. Then you filed a petition in 2002. What happened then?
Directed to release my car in service to. In spite of that, my lord, they are not releasing. Now I have approached this where we go by your second order. Thereafter, my lord, inquiry was conducted.
Hmm.
The lordship I kindly look into my lord, the inquiry is
Hmm.
conducted by deputy superintendent
Where?
and given to the honorable superintendent.
Where is it?
9/1/2009.
Huh? No, you have not enclosed. Right? They will say all these things that we don't know.
Inquiry was conducted in the year 2019. But the filing of the
There is an affidavit in opposition filed by on 2019. There is a report dated 24/5/2002. Are you referring to that? Copy of the report dated 24/5/2002, Annexure 11. So what is the price at which you have purchased the vehicle?
time of purchase, well, 2,20,000. At that time.
Yes, government. You pay this 2,20,000 to him. There's nothing else. I think that is the only way. As of now, you have not done it. If you are to pay the rent and all, it will go to any limit. So you pay the 2,20,000. I think that. No, Mr. Chaudhary, I think this is the fair thing. Whatever they have done, the price of the vehicle is what you can get.
So many years. 2001, 2005, second order litigation on it.
Understood. But if what happened, the problem happened is in 2002, you filed a writ petition. there was a direction to release. And the requisition was disposed of in 2010. Almost 8 years have gone. 2009, 1 until today, it's 2023. So under such circumstances, there has been some lack of diligence also. So I think the best way out is to get that I direct them to pay that within 45 days. That is the only way out. Because this is nothing. What is the value of it? Do you have anything? Memo, invoice, anything?
Everything was, that is the, everything was.
So how do I fix it at 2,20,000? Statement is there. Where? Only give me that. Where is it? One statement. Two lakh 20, yes, got it. You add page to the affidavit file, additional affidavit filed on 5th of March 2019, paragraph number 5. Isn't it? There's so many affidavits filed. Yes, I've seen it. No, you have put it on affidavit. See, your affidavit filed on 11th of February 2021. For a, isn't it? So you pay this 2,20,000. That is the only way out. And should I give you the liberty for filing any other compensation shall be subject to what you do as per the, but this is the value of that is the value of the card which I am giving it. As regards any other further compensation, if you want, you can, as regards the loss or damage which has been done, you can file it civil suit. Because that I can't do it. The instant reputation. The petitioner herein being aggrieved at the action of the respondent authorities in requisitioning the vehicle of the petitioner and not returning the same till date. Not returning the same. Has been compelled to approach this court for the second time by way of the instant writ petition. From a perusal of the materials on record, it reveals that the petitioner herein had purchased a Maruti van bearing registration number AS15/3225, 3227, at a price of rupees 2,20,000. From one Mohammad Minul Hussain. The same vehicle, the petitioner used the same vehicle as a taxi, for which the petitioner had also obtained a permit. On 16/4/2021, the additional Deputy Commissioner Borpeta, by an order, requisitioned the vehicle of the petitioner in terms with Section 160, read with Section 166 of the Representation of People's Act 1951, and thereby directed the petitioner to report the said vehicle of the petitioner along with his driver and spare tires on 17/4/2021 at 8 a.m. Thereafter, the said vehicle have not been de-requisitioned or returned to the petitioner. Under such circumstances, the petitioner was compelled to approach this court.
Under such circumstances,
Just do that.
thereafter the said vehicle have not been requisitioned or returned.
Return to the petition, for which the petitioner had approached the concerned Deputy Commissioner Borpeta by various representations. As the same representation submitted by the petitioner bear no result, the petitioner was compelled to approach this court by filing a writ petition, which was registered and numbered as WPC number 2981/2002. In the same writ proceedings, this court, while issuing notice on 13/5/2002, directed in the interim the respondents to release the vehicle of the petitioner in serviceable condition. Thereupon, then also, the respondent authorities did not return the vehicle to the petitioner. The petitioner thereupon also the vehicle was not released to the petitioner, for which the petitioner not only was deprived of the vehicle, but also the loss which had incurred to him. not, but also the business laws which also occurred to him. The same petition, that is WPC number 2981/2002, was disposed of by an order dated 18/5/2010. Observing inter alia that by the interim order dated 13/5/2022, the writ petition was, the final relief was already granted in the writ petition. And accordingly, the writ petition was disposed of in terms with the interim order dated 13/5/2002. Huh? What this? Thereupon also, nothing happened, and the petitioner was compelled to compelled to submit representations as well as issue notice, a legal notice to the respondents herein. The representations of the petitioner as well as the legal notice fell into the deaf ears of the respondents, for which the petitioner have been again compelled to approach this court by filing the instant writ petition in the year 2014. From the records, it reveals that on 28/11/2014, notice was issued various affidavits have been filed by the respondent numbers 2, 3, 5, and there were 2 additional affidavits filed by the respondent number 3 and 5. all of you respondents tell me where is the letter of de-requisition? You have to de-requisition. Where is that letter? I don't know anybody, but I'm only asking where is that when you are requisitioning the deputy commissioner, where is the de-requisition? Because what you are saying that the requisition was made on 16/4/2001. Thereupon, there are certain mentions being made by the OC Azara police station and other that in the month of November 2001, the vehicle was caught somewhere without a number plate. So was it pursuant to your de-requisition? There's not a single document to show the de-requisition. And unless you exercise the power of de-requisition, the vehicle will continue to remain with you. From the affidavits so filed by the petty respondents, there is no mention whatsoever as to when the vehicle of the petitioner bearing registration number so and so was de-requisitioned. Although there has been various statements being made to that effect, that in connection with some case pertaining to the vehicle being driven without a number plate, the vehicle was seized. But without the de-requisition being made, the custody of the vehicle continues to remain with the Deputy Commissioner Borpeta, who has requisitioned in terms with Section 160, read with Section 166 of the Representation of People's Act 1951. Therefore, all the statements so made in the petition pertaining to that the vehicle was seized in connection with the vehicle being driven without a number plate in the month of November 2001 has no relevance. The record further shows that the petitioner had filed an additional affidavit, not only claiming the amount, not only claiming the value of the vehicle, which was at rupees 2,20,000, but the petitioner had also claimed various other amounts on account of the business loss which has occurred to him. This court further finds it relevant to take note of the additional affidavit filed by the respondent number 3, who is the additional Deputy Commissioner Borpeta, wherein it has been mentioned that in order to compensate the petitioner, there was a move for getting necessary sanction for funds but as the matter is pending before this court, the same amount has not yet been determined. Next. In the backdrop of the above facts, it is seen that the vehicle of the petitioner admittedly was requisitioned on 16/4/2001 was requisitioned by the order dated 16/4/2001, and the custody of the vehicle was handed over by the petitioner on 17/4/2001. There is no materials on record shown that the vehicle in question was handed over to the petitioner thereupon, or that the vehicle in question was de-requisitioned by the respondent authorities. This court also cannot be unmindful of the fact that on 13/5/2002, there was a direction by this court in WPC number so and so, directing the respondent authorities to release the vehicle. And thereupon also the vehicle have not been released. When the instant writ petition is now being taken up in the year 2023, and more than 22 years have already elapsed, the condition of the vehicle, as could be also seen from the MVI report dated, it is not known as to what would be the condition of the vehicle now. But it can be presumed that the said vehicle would not be in a position would not be in a position, or would not be in a condition by which the petitioner would be able to carry out his business. Under such circumstances, it is the opinion of this court that the petitioner at the least is entitled to the value of the vehicle, which is rupees 2,20,000, as stated in his additional affidavit. Accordingly, this court has also duly taken note of the submission made by the learned counsel for the petitioner that apart from the value of the vehicle, the petitioner is entitled to further amounts on account of the business loss during this period of requisition. In the opinion of this court, the said cannot be ascertained in the proceedings under Article 2 to 6 of the Constitution. But the fact that, as the petitioner at present had been agitating the said rights before this court, claiming the said compensation for the business loss, diligently, liberty is given to the petitioner to approach the civil court claiming such compensation as deemed fit. And it being a continuing cause of action, and the petitioner have been diligently fighting for his business loss to recover his business loss. The period of limitation for filing the said suit, if the petitioner approaches the civil court, the competent civil court, these aspects of the matter would be duly taken note of while computing the period of limitation, including the benefit under Section 14 of the Limitation Act 1963. Next. In that view of the matter, the instant writ petition therefore stands disposed of with a direction to the Deputy Commissioner Borpeta to disburse to the petitioner an amount of rupees 2,20,000 within 45 days from the date a certified copy of the instant order is served upon the Deputy Commissioner Borpeta. It is further observed and directed that if the Deputy Commissioner Borpeta fails to pay the said amount within the time stipulated herein above, the petitioner not only would be entitled to other rights and other remedies on account of the violation of the directions passed by this court, but would also be entitled to interest at a rate of 12% per annum from the date of completion of the 15 days, from the date with effect of 12% from the date the default is committed to the directions so passed.
Number 5.
So what should I do? Put your name out there that I am appearing for response number 5. Give your names. All I have nobody, not put even the petitioner's lawyer's name. Give your name, all will be taken. Huh? What is this matter about? What are you asking for? Contractual work. Why? You have not paid?
This one directed the secretary, Panchayat will is first and having order takes 103. The reason of the find it 104.
No. Has there been a verification carried out?
The thing is that the inquiry is not found.
Huh?
Could not be found.
The amount could not be found.
Find the finding it at 105.1.
Yes.
105.1%.
After going through it is seen that the total fund received by the Jilla Parishad under so and so during the year after discontinuing one, and the amount received by the JP Darang was demand. So the question of clearance of the pending bills, which appears to be between so and so to so and so from the state share, which was released by the state, does not arise.
Then point number 2.
17 numbers of schemes were found to be executing detention. The reason for non-payment of bills in question out of the available funds of the fees could not be confirmed.
It is not confirmed. Point number 2.
Schemes in question was executed in favor of Eviction. Yes.
One of the question has been raised that it was executed without the committee being, there is approval for committee also, for the committee. But under the scheme.
What did you do? Who are you?
For this scheme, 6.7.3.
Who are you? How many people?
61 law.
Have you all paid your dues?
That is not.
Have you all paid your court fees?
So that
Why? You choose one of it. Anybody? Raju Ahmed, Imran Haq, Nizam Ali. Anybody? Will pass the order in his favor. No.
I will take a deficit for.
Only one person. Yes.
Actually, the fact that there are a lot of
Huh?
there are a lot of facts. They claim that they have actually carried out work for all the schemes, 67 number of schemes. There is a statement of work which has been submitted by them. I will just get into that. Statement going to starting from page number.
No, Mr. Chakraborty, you have to understand one thing. You can't file this type of petition claiming here. And you have put it for common cause of action.
Earlier we approached individually.
So what?
Common order has been passed.
So,
Disposing on the.
yeah, there might be a common order passed in 100 petitions. Yes, that is a different thing. But doesn't mean that you are going to file one appeal. No, everybody has to file an appeal. That is the very essence of Order 41, Rule 1. Then, Why everybody's claim is there? That is why it cannot be asserted. Nobody can do it. What is the basis on which you are claiming that you are entitled to this 58 lakhs? How can this court direct this 58 lakhs? No, there is somebody who have done it. There is some order being passed on 15/9/2012, rejecting the claims of the petitioner for payment of the outstanding dues. So you go before the civil court. That is the only way. Why should this court once? No, Mr. Chakraborty, kindly appreciate one thing. Once the civil court has this at best, what can this court do? No, Mr. Chakraborty, kindly tell me one thing. Can this court adjudicate whether you have done the work or not? Now tell me, honestly. No. Can this court do or ascertain that you have done the work? No. That is a question of proof. No, Mr. Chakraborty, it's a question of proof. That we will see. Have you proved this annexure 4 in a manner in which where is the original of annexure 4? No, you are to prove. Then if you want to go by the civil court, we'll do it. Now tell me, how do you prove this? Whose signature is this? No, tell me, one thing. Annexure 4 is whose signature? Not forget about the affidavit, I'm not concerned. Mr. Chakraborty, tell me, whose signature is this? Who? No, who? Let us go by the civil court as per the evidence act. No, I'm asking you. Not necessary. Then also this court has to be here. Now tell me whose signature it is. No. If you are saying this, I am not concerned with all other affidavits. Now kindly come here. They say that they have rejected your claims for your amount. You have no other option now because this court can, at best, the only direction this court can pass is directing them to verify and pay. Now this court cannot do it because of that order where they have said rejected your claims. Not necessarily. Then also they have made the pass that order. And unless you show that that order is perverse, tell me. No, Mr. Chakraborty, you just show me that order of 15/9/2012 is perverse. Show me that. That's all.
Page 106.
Okay.
Point number 5. Point number 5. Instead of engaging local rural poor wage earner, the schemes were executed by the petitioner for the construction company. What has been executed then? Is there admit lawsuit?
The scheme were without instruction. No, then next one.
The works undertaken by the petitioner in the field were without any instruction from them. But what has been executed?
Then why did you do?
Only the procedure there on the procedure.
If you want, let us go as per the rich jurisdiction or civil. I give you two. I don't mind being a trial court also. Tell me. Let me do it. Prove this document. Prove this document. Let's go by the civil court.
They have made part payment lawsuit.
You should be happy with that.
Procedure statement is there lawsuit.
The part payment may at best enhance your limitation. Nothing more than that. These type of cases has to be.
But total 67 number of schemes, the statement that they have actually annexed to the annexure 3 series contain names of 68 schemes, madam, and more. And apart from that, madam, the para page 103, that's the order passed by the society. And the last para, page number 103.
In view of the above, I have come to the conclusion that the claims of the petitioners are not found to be justified and hence the claims could not be accepted.
Once for page 99.
You show me that it is justified.
Possibly page 99.
Yes.
Page 99. The second line also.
It appears that the fund available under the same amount of remand.
By the government, the school is not in a position to read. The observation date in the idea down to date. So what executed that has not been denied. Only because of one, some amount should not be released.
Inquiry that was conducted. They have claimed that they have done all the schemes.
What is the direction given by this court? In view of the above, the present petitions are disposed of, directing the principal secretary to the government of Assam Panchayat and Rural Development to look into the matter, and after considering the communication dated demand, to pass an order with regard to the claim of the petitioner, and also to issue appropriate direction to the CEO, the Dorong Jila Parishad according. Now they say out here that these claims which have been made out there is not tenable, not justified. You show me how it is justified.
What is the executive document?
So, did you have the permission? Can a person execute on the basis of permission? Don't show me all this. You have not brought on record. No, not necessary. 2014 matter. Are we here to mention it out here that 2014 matters also now? Every time they want to file an affidavit.
No, scheme of the Sakun Gramin Rozgar
That's the work of the file. Submit one to another.
No, you submit, but you have not filed affidavit.
On the basis of the order, just the order, isn't that very clear? There were totally 7 numbers.
Huh?
They show 68 numbers that of which the work has been done. However, the last paragraph, we follow 103, stated matter. And before that, if we come, madam, it says.
Whereas the above three committee members have submitted the inquiry report on demand, and where from it appears that the inquiry team found only 17 numbers of schemes of the petitioner tally with the list of schemes furnished by the CEO in his letter dated so and so, and accordingly its report was based on those 17 schemes.
Then, madam, all the inquiry team during this total inquiry examined the record, but it was not expected to report whether annual action report was approved by the competent authority as well as technical submission of the schemes were recorded or not. Then, madam, the next paragraph is even more important. Whereas it appears from the inquiry report that out of 17 schemes, the inquiry team could trace out only 4 numbers of schemes from the action plan of 2006-17, and the total estimate amount of just 4 numbers of schemes was 5 lakhs, out of which an amount of 4 lakhs was received by the pensioner as per the. Which only 4 schemes. What is the amount of?
And the total estimated amount of the 4 schemes were rupees 5 lakhs, out of which 84,000 has been received by the petitioners as per the record. Have you got anything more than that? 84,000. Have you got more than 84,000?
How much individual of the petitioner?
This is wrong, madam. The total number of schemes that mentioned over is 68.
Mr. Chakravarti, I'm coming in another 10 minutes. You take a decision whether to approach the civil court or I dismiss the petition. Both cases it will be dismissed, but one, the liberty will be given to you to the civil court, and taking into account that you have been diligently filed, and the other is without civil. You just take that decision now. That this has nothing. This. "61 petitioners have joined together and filed the instant petition challenging the order dated 15/9/2012 passed by the Principal Secretary to the Government of Assam Panchayat and Rural Development Department, whereby the claims of the petitioners for payment of their outstanding dues were rejected, and also seeking a direction upon the respondent authorities to release or pay the admitted amount of rupees 58 lakhs 198, 58,00198 to the petitioner on account of contractual work performed and executed by them under the SCR scheme of Dorong Jilla Parishad. The facts of the instant case, as could be discerned from the perusal of the writ petition, is that the petitioners claimed that they were allotted various contractual works by the Dorong Jilla Parishad under the Sampurna Gramin Rozgar Yojana, bracket SGRY, bracket close, for the financial year 2006-07. It was alleged that the petitioner carried out it was alleged that the various works were carried out by the respective committees headed by the petitioners as president of the said committees, which were supervised by the assistant project officer bracket technical and the junior engineers working under the Dorong Jilla Parishad. The petitioners claimed that they had completed the allotted works within the stipulated time without there being any complaint as regards the nature and quality of the work, but the petitioners have not been paid their outstanding dues, except making a meager part payments. The petitioners further claim that their total outstanding amount to which the petitioners as a whole are entitled to is rupees 58,00,58,00198 against 67 numbers of schemes. Various representations were submitted from time to time by the petitioners, but said amounts were not paid, for which the petitioners filed separate petitions before this court. This court, by a common judgment and order dated 8/6/2011, disposed of the said writ petitions, thereby directing the Principal Secretary to the Government of Assam Panchayat and Rural Development Department to look into the matter, and after considering the communication dated 1/7/2009 to pass an order with regard to the claims of the petitioners, and also to issue appropriate directions to the Chief Executive Officer, Dorong Jilla Parishad, accordingly. And the said exercise was directed to be completed within a period of 2 months. The petitioners, upon receipt of the certified copy of the said judgment, placed it before the Principal Secretary to the Government of Assam, Panchayat and Rural Development Department for compliance to the directions passed. Thereupon, the impugn order dated 15/9/2012 was passed by the respondent number 1, which have been put to challenge before this court. From a perusal of the requisition, it transpires that it is on account of the order dated 15/9/2012 that the petitioner have not been paid their claims. And as such, it is necessary for this court to analyze as to whether any interference can be made to the order dated 15/9/2012. As well as also see or also take into account that as to whether a writ in the nature of certiorari can be issued, challenging the said for setting aside the said order. Taking into account that a writ of certiorari has to be issued in the instant case, this court finds it relevant to take note of a recent judgment of the Supreme Court in the case of Central Research so-and-so reported in so-and-so, wherein in paragraph number 50, 51, and 52, the Supreme Court observed that there are two cardinal principles to be followed by this court, by a high court, while exercising the power for issuance of a writ of certiorari. The same paragraph 50, 51, and 52 are quoted here in below. Today, Central Council for Research in Ayurvedic Science and another versus Bikarton, Das and others, reported in 2023, SCC Online SC 996. From the above quoted paragraphs, it would be seen that out of the two cardinal principles of law governing exercise of extraordinary jurisdiction under Article 2 to 6 of the Constitution, more particularly when it comes to the issue of a writ of certiorari, the first cardinal principle is that the High Court does not exercise the powers of an appellate tribunal. It does not review or reweigh the evidence upon which the determination of the inferior tribunal purports to be based. The High Court only demolishes the orders which it considers to be without jurisdiction or palpably erroneous, but does not substitute its own views for those of the inferior tribunal. It has been also observed that a writ of certiorari can be issued if an error of law is apparent on the face of the record. And a writ of certiorari, being a high prerogative writ, should not be issued on the mere asking. The second cardinal principle for exercise of the extraordinary jurisdiction under Article 2 to 6 of the Constitution is that if some action or order challenged in a writ petition is found to be illegal and invalid, the High Court, while exercising its extraordinary jurisdiction thereunder, can refuse to upset it with a view to doing substantial justice between the parties. It was observed that it is perfectly open for the writ court exercising this flexible power to pass such orders as public interest dictates and equity projects. The legal formulations cannot be enforced divorced from the realities of the fact situation of a case. Further to that, the Supreme Court goes on to observe that while administering law, it is to be tempered with equity, and if the equitable situation demands, after setting right the legal formulations, not to take it to a logical end, the High Court would be failing in its duty if it does not notice equitable considerations and mold the final order in exercise of its extraordinary jurisdiction. The Supreme Court goes on to observe that any other approach made by the High Court would render the High Court, while exercising its extraordinary jurisdiction, a normal court of appeal, which it is not. Now, coming back to the facts involved in the instant case, it would be seen that pursuant to the order passed by this court, the PNRD department had entrusted to cause a detailed inquiry into the matter by the order dated 26/8/2011. A joint secretary of the PNRD department had submitted his inquiry report on 22/2/2012. Which was found by the PNRD department to be not in order. For which a 3-member committee was constituted, comprising of one joint secretary of the PNRD department, one joint director, bracket tech, and the commissionerate of tech, commissionerate of PNRD, and the financial advisor, PNRD department, to re-examine the matter. The three-member committee thereupon submitted the inquiry report on 26/7/2012, wherefrom, full stop. In the said report, so submitted on 26/7/2012, the inquiry team found only 17 numbers of schemes of the petitioners tally with the list of schemes furnished by the CEO in his letter dated 1/7/2009. And accordingly, the report was based on these 17 schemes. It was found further that out of the 17 schemes, the inquiry team could trace out only 4 numbers of schemes from the action plan 2006-07, and the total estimated amount of these 4 numbers of schemes were rupees 5 lakhs, out of which an amount of rupees 84,920 were received by the petitioners as per their records. It is also apparent from the inquiry report that the government of India, by the letter dated 23/3/2007, had issued certain directions, which were number Roman 1, no new SZRY work should be taken up with effect from 23/3/2007, as no further fund would be released under SZRY during 2007-08. Roman 2, all works undertaken under SZRY should be completed by 31/3/2007. And Roman 3, if such schemes cannot be completed due to unavoidable circumstances during 2006-07, that is by 31/3/2007, the schemes may be completed with the balance available fund on 1/4/2007 under the SZRY at the earliest. Pursuant to it also appears that pursuant to the government letter dated 23/3/2007, the government of ZAM had also, government of India, I got to government of India, pursuant to the government of India's letter dated 23/3/2007, the government of India issued another communication dated 14/8/2007, stating that in case there are still incomplete SZRY work in NREGA phase Roman 2 districts, bracket, where the Durham district was covered, bracket close, has to be closed with effect from 31/8/2007, and no further expenditure is to be incurred on them. It was further directed by the said letter dated 14/8/2007 that the entire balance work of the SZRY as on 31/8/2007 balance funds must be transferred immediately to a separate account created for NREGA works, if not done so far. It is further mentioned out there in the impute order dated 15/9/2012 that as per the inquiry report, that in terms with the inquiry report, as per office record of the CEO Jila Parishad Dorong, the closing balance under SGRY as on 31/3/2007 was rupees 4,26,287. And the CEO Jila Parishad Dorong received an amount of rupees 97,63,000 under SGRY program during the period from 7/4/2007 to 6/6/2007, out of which the amount received on 6/6/2007 was rupees 37,48,000. It was further mentioned that after discontinuance of the SGRY scheme, the total available fund of the Jila Parishad Dorong during 2007-8 was rupees 1,90,283, of which an amount of rupees 1,65,834 was spent, leaving a balance of rupees 24,449 till closure of the SGRY scheme as on 31/8/2007. Further, it was also mentioned that the 17 numbers of schemes which were duly taken note of by the inquiry committee were executed during the period from February 2007 to May 2007, and the total estimated amount of the schemes were rupees 17,35,000, out of which an amount of rupees 3,80,592 were paid. The reason for non-payment of the bills out of the available funds of rupees 37,48,000, which was received by the CEO Jila Parishad Dorong on 6/6/2007, could not be confirmed by the inquiry team. It was, however, mentioned that in the inquiry report, there was no instructions of the orders from the CEO Jila Parishad Dorong to execute the works by the petitioners. In the impugn order, further, in the said impugn order dated 15/9/2014, 12, the various guidelines of SGRY were taken into account. And thereupon, the conclusions have been recorded in the said order, which are enumerated herein under. Page 105 of the book, 1, 2, 3, 4, 5, and 6. From the above conclusions so arrived at by the impugn order dated 15/9/2012, it reveals that as the total fund received by the Jila Parishad Dorong under the SGRY scheme during the year 2007-8, as on 6/6/2007, bracket, after discontinuation of the SGRY scheme, that is after 31/3/2007, bracket close, was rupees 1 crore 1,90,283, and the amount received by the JP Dorong on 6/6/2007 was rupees 37,48,000. And as such, the question of clearance of the pending bills, which appears to be in between February 2007 to May 2007, from the state share, which was released by the state government after 31/8/2007, does not arise. It was further observed in the conclusions that that 17 numbers of the schemes were found to be executed during February 2007 to May 2007. And the reason for non-payment of the bills in question out of the available funds of rupees 1,90,283 could not be confirmed by the inquiry team. It is further seen that for amount that the state share, it is further seen from the conclusion arrived at that the state share, which was released by the state government after closure of SGRY account, that is after 31/8/2007, was deposited in the new NREGA account as per the Government of India instructions. It was also concluded in the impugned order that the schemes were executed by the petitioners through construction committees by constituting themselves by suo motu will, instead of engaging local rural poor wage earners. Further to that, it has also been mentioned that the works undertaken by the petitioners in the field were without instructions from the CEO JP Dorong, as well as it appears to be executed before the receipt of its due share by the JP Dorong, which is in violation of the isn't it AFRBM Act rules. You have a rule or act? It's an act. FRBM rules below. It is on the basis of the said conclusion that the claims of the petitioners were found to be not justified and hence were rejected. Now, Mr. Devnath, kindly say, you had the money of 1 crore, you have returned the money. The fact that they have done the work is not in question.
For 5 lakhs.
Not 5 lakhs. What 5 lakhs? The total amount from February to May.
What I stated in page 104.
105 down below. Total fund received by Jila Parishad Dorong under so and so during so and so was rupees 1 crore 1 so and so. This is for the SGRY. And the amount received by so and so on demand was so and so. So the question of clearance of pending bills, which appears to be between so and so from the state share, which was released by state government after demand, does not arise. This is one. Now kindly come thereafter. 17 numbers of schemes were found to be executed during February to March. The reason for non-payment of the bills in question out of the available could not be confirmed. Where is his finding? Why?
So that
Huh?
why manner?
You see, they have worked, they have to get it. After getting all the work done, can you now say that no, bye-bye?
They did not do all the.
No, whatever you have done, but why have you rejected the entire amount on the ground? Now you have reposited as per to the NREGA scheme. Very well, you have done it. But the fact that you have deposited out there in the NREGA scheme, does it say that you are not going to pay to them?
That would be a correct of the part, the payment at the balance amount also will pay. The balance amount of the of the work done of the value of the 5 lakhs.
Hmm?
The balance amount after having made the
No,
payment.
this amount for the 17 numbers of schemes were found to be executed so and so. The reason for non-payment in the bills could not be confirmed by here. Now, where does it say anything?
As per the petitioner,
This amount we have received. 1 crore, 1 lakh. Why haven't you paid that amount? This amount for 7. Kindly come at page 106, serial number 2. Why?
this is actually something.
And this can be very well seen from the next one, number 4. The state share which was released by the state government after closure of the SGRY account, that is after so-and-so was deposited into a new NREGA account as per so-and-so. So you have deposited the state share. Although it was some 24,000, you have done it. Somewhere it is being mentioned, no? Yeah. Page 104, in between. Was spent leaving a balance of rupees 24,000 forward till closure of the year on so and so. You get it? 104, the 4th paragraph, whereas it appears from the inquiry report. And you see the next one. The total estimated amount of the scheme was 17,35,000, out of which an amount of rupees 3,80,000 was paid. The reason for non-payment out of the available funds could not be confirmed.
However, it appears only in 24 that there was no instruction from the CEO Villa Mutation to work by the petitioner. So as far as the number of work they have done is actually number of schemes, what they have done is 4 items, and in the second part of the very big number. Whereas it appears from the inquiry report that out of 17 schemes, the inquiry team could trace out only 4 numbers of schemes from the action plan of 3617. And the total estimated amount of this 4 numbers of schemes was 5 lakhs, out of which.
No, this was for initially for 2006-07. 4 numbers. Then after that, it became more. Because during this period, this happened from February to May.
Petitioners have done work for the financial year 2006-07.
Understood. But you see, these schemes were given well. You see, this paragraph down below.
They should have, they also have ended by the 31st of March 2007.
But then also you gave it till May.
Only with regard to those work that was. As to whether they were work was completed, I don't know.
Huh?
As to whether these petitioners were completed by 31st of March or it went on to the
No. It was extended till 31/8.
that was with regard to the still incomplete work.
Understood. Till 31/8. Now they say they have completed. That is what they say. But these are questions of fact, which I can't go into. Now these are the facts. Now on the basis of which, one thing is that there's some payments could not be made. Why it is not made, he has not come to a finding. Isn't it?
But then the inquiry report is separate from this one.
Understood. But what is the conclusion out here? Why certain payments could not be made is not final. He only says that there has been violation of the guidelines. Now, have you mentioned that the violation of the guidelines, these were works which were allotted by the Zilla Parishad? They have done the work. Now, if there is a violation to the guidelines in allotting it, then why not the concerned Jilla Parishad people pay? Absolutely, if it is so. No. From the above, it therefore reveals that although the petitioners claim to have completed works pertaining to 67 schemes, the three-member committee only found that only 17 schemes of the petitioners tallying with the list of schemes furnished by the CEO on the basis of the same 17 schemes. The inquiry committee could only trace out 4 numbers of schemes from the action plan 2006, there's 7. It is also seen from the impugned order that there is an admission to the effect that there were 17 numbers of schemes were executed during February 2007 to May 2007. And the total estimated amount of the schemes were rupees 17,35,000, out of which rupees 3,80,592 was paid. The inquiry report so submitted, however, did not state as to why the said remaining amount could not be paid out of the available fund with the Jilla Parishads, Dorong. It further appears that the inquiry report there is a mention that there was no instructions of orders from the CEO, Jilla Parishad Dorong, to execute the work by the petitioners. It further shows that there has been certain allegation that there is a violation to the guidelines, to the SCRY guidelines, more particularly to clause 5.16.1, 6.1.1, 6.1.5, and 6.6.1. System. It also transpires that there are admissions to the effect in the same order itself. That the 17 schemes were executed by the petitioners through construction committees by constituting themselves, through construction committees constituted by themselves. Therefore, the fact as to whether the petitioners are entitled to any amount or not still remains inconclusive. In view of the report on which the impugned order was passed, more so in respect to the 17 schemes which were duly taken note of by the inquiry committee. It is also relevant to take note of that these aspects of the matter as to whether the petitioners have completed the said schemes, and whether the petitioners were allotted the work in terms with the guidelines, SCRY guidelines. As to whether the petitioners, completed the work as per the allotment so made to the petition, as per the allotment of the work made to the petitioner. As to how much amount the petitioner would be entitled to. Are factual determination which cannot be made by this court under Article 226 of the Constitution. Be it as it may, the order which was passed on 15/9/2012, in the opinion of this court, is an inconclusive determination so made. And on the basis of the said order, the petitioners cannot be denied the entitlement on the basis if the petitioners prove in a competent court of jurisdiction that they have been allotted the work as per the guidelines and they have duly completed the work and have also received and have also and is entitled and accordingly is entitled to any amount. This court also cannot be unmindful of the fact that the claim as regards the entitlement of the amount has been pursued by the petitioner from since 2009 itself, when the petitioners filed the first set of petitions, and thereupon the petitioners continue to be challenging, continues to be diligently pursuing the remedies for claiming the amount to which the petitioners are entitled to. This court, being a court under, while exercising jurisdiction under Article 226 of the Constitution, cannot adjudicate these factual aspects which have been referred to here in Supra. And as such, the adjudication the adjudication so sought for as regards a direction for payment of as such the relief so sought for a direction for an amount payment of an amount of rupees 58,00,101 to the petitioners cannot be issued by this court. Under such circumstances, the instant with petition stands disposed of, thereby granting liberty to the petitioners to avail remedies before the competent civil court against the respondents, claiming the amount due to them on the basis of their contracts. oblique allotments, contracts oblique award on the basis of the contracts. And the order dated 15/9/2012 shall not act as a bar in granting the petitioner their release if the petitioners are in a position to prove their entitlement in the competent civil courts. This court further observes and clarifies that taking into account that the petitioners have been pursuing their remedies diligently before this court since 2009, the petitioners will be entitled to the benefit of the statutory, the benefit of Section 14 of the Mutation Act 1963, while if any suit is being filed. Nothing more I can do.
In my condition.
Hmm.
That also identification for a document. Identification of the plot of land.
What are these so many writ petitions? Why? Contempt, writ petitions, why?
I'm coming.
Huh?
Like my father occupied was a standard for a particular plot of land. Amounting to 3 acres. And that after he.
No, Mr. Somwa, first let me get a glimpse of it. Why are there two writ petitions?
Yes,
Tell me.
there are two reasons. That particular plot of land.
No. Why 2014 petition was filed for what purpose?
They served an issue.
We'll see the
They served
facts.
an notice.
We'll go to the facts later on.
Yes.
What are you asking for?
Yes, they not.
For setting aside an impugned eviction notice.
That is the case 31 of that.
Impugned in so and so, reflected in so and so, in an eviction, directed petitioner who is a recorded remand from the civil land without affording an opportunity. So this is for evicting you
Fine.
from where you are a riot,
Fine.
recorded riot.
Yes.
So this is why this writ petition was filed.
Yes.
Hmm.
That is the.
And in accordance with the provisions of law, even directed to settle the civil land. Now, have you filed an application under you are right?
Yes, I know that. My father was then it came to me. He was the-
Okay, so your father was a right.
that is-
Now, how does the settlement happen?
Pardon me.
How can there be a settlement of a tenant? Right means a tenant.
Yes, I'm a tenant, but.
You are a right under the 71 Act,
Yes. I applied for ownership under section 3.
under that act.
Yes.
So that act will take its course. Why you are asking for a writ?
Yes. That is it, coming for, you know, this requisition 2639/2014, there's an interim order passed by this court. When this eviction notice was initiated by the state, then we approach this court. Second that I am a tenant, you cannot evict me. I'm a recorded tenant since 1923, I'm fully recorded. Then this lordship will kindly see the order passed by this court on 35/2014. Even after this order, there was granting the stay of the eviction case. I was evicted.
Oh, so that is the second one.
That is this is why the second one and a contract. Now we learn. The lordship is taking up why there is a confusion, why state not exactly stay. The circle officer says this is the government. According to the circle officer record, this is the government. According to the deputy commissioner, no. I am the tenant there. There's recorded tenant. The
So
confusion.
show me your Khatiyan.
There.
The first writ petition.
Yes.
You are concerned with which term? Because the moment you are a Khatiyan, you can't be a Khatiyan holder under the government.
Oh, I'm the under the landlord.
Yes, landlord. And where is the landlord? Where is the landlord?
Landlord, because it's not a party here,
Why?
because I am not claiming to visit against him. He has not evicted.
Don't you think he's an important party? In a matter where you are the tenant,
My.
that in effect, the right, actual right of that person, because that person still continues to entitle to, even under 21 and 23 also, if you're entitled to the settlement
Right.
or occupancy right or right of the title, then also he has a right to receive compensation. Anyways, let's not go into those. You are not, he is. You have to know whose actual right it is over the land. Actual right it is of that person concerned.
Right, but
He is not a party to the instant proceedings.
I appreciate. Eviction notice was served upon me.
Obviously, you are the possessor. Eviction notice will be served upon you because you see, why an eviction notice is issued? The eviction notice is not issued on a person concerned on the basis of ownership. Obviously, he can't be the owner. You are possessing the land, so your notice will be issued to you because it presupposes that it is a government land.
Right.
Now, let's not go into those things. Let us now first see where is the Khutian.
But here is logical here phase 19 annexure A.
Annexure?
After
Yeah.
the first one, logical, let's see this one.
Certified copy of the draft sheet of Pochim Boragaon under Muza Jalukbari for the year 57-58. Dark number old. New.
That photocopy is not good.
Huh?
This is the original one I am giving.
Seven 30 dark. 574 oblique 1171.
This Vijay Bhagwan,
So
my father.
it's 6 or 5 bigas. 5 bigas, 2 kathas, 7 lesas.
But
And it is in the name of Asunur Ali. He's your landlord.
He was one there.
Okay, that is okay. And then Rayati's name is there.
Yes, for next one.
Viren Borguhai. Okay. So,
Vijay Bhagwan is my father.
understood. Rayati's name is there.
Then my, it came to my name, you know, you see. This one.
What I want to say. Now, let's see your Khutian.
Yes, that. And you are one more.
Interesting.
These are in the records, in the requisition itself, but copy may not be good, that is why I am giving the original.
You are occupying the entire land.
3 bigas to the.
Huh?
3 bigas to the.
3 or 5 bigas. 5 bigas, 2 kathas, 7 lesas. No, it is there out here. In the Khutian which was issued under 301 Khutian number,
Yes.
it has been mentioned, your name is now mentioned, na? Bulbuli. And this is 674, 574, 771, Nutun 730, 20, 5 bigas, 2 kathas, 7 lectures. One third of the principal. Now what happened thereafter?
Well, the eviction notice was served, but you can see at page 31 of that.
So you file an application under 23(1).
Yes, yes,
Oh, so that you have done it.
yes, that I have done.
What has happened to that proceedings?
It is still pending.
Oh, they have not numbered it till now.
No.
Then eviction notice was
Eviction
issued under
notice served on
18(2). Eviction case number so and so, circle officer as per the report so and so. Oh. 704. 704 is not the dark. Your DAG is not 704.
No, that is income. That is 1688. So you can see
Ah,
in 31.
No, I'm coming into it.
That's a different.
No, I'm coming.
so this is a different DAG.
And that the circular officer has clarified.
Huh?
That the two DAGs are different. The DAG in which he is claiming for occupancy right is 730. And the eviction, where eviction was done, that is in 1688.
Not just that letter, let me complete my friend, allow me to complete. If
No,
you
no,
want
no,
to
it's okay.
wait for his man.
Then what happened?
Why not, there is a letter from the,
Are you in occupation of this DAG?
why not this, there-
No, no, Mr. Somoa. Are you in occupation of DAG number 1688?
yes, Milord. I mean.
Huh? How can you be in
Why-
occupation
that
of
is
1688?
that, my lord will see. That is why I wanted to show a document. Lordship will kindly come to the, there is the additional affidavit I filed in that.
Yes.
There is a letter issued by the deputy commissioner to the government.
Ah,
And-
Where?
That,
Where, in which case? A year? Ah, what letter? Yes.
I don't see 6/1/2022 letter.
Page?
Page 9 and it's
Yes. Ah,
kindly read this letter will clarify. Where it. Ownership back in favor of Srimati Gurguli Bormohan, daughter of Viren Bormohan, who was the recorded tenant. With reference to the subject cited above, I have the honor to inform you that the petitioner Srimati Gurguli Bormohan, daughter of Viren Bormohan, has applied to get ownership right of land regarding 3 Bigha 2 Kata Devadatta, covered by that number 7044 on 1688, the king of 20% number 155. Hearing criteria number 301 of village Paschim Bharat under the Dalupuri Moda as per provision of Rule 16 of Assam Temporary Supervisor Currency Act 1971. While examining the draft Shikha of village Paschim Bharat in the year 1923-28, it has been observed that the name of one Viren Bormohan was recorded as tenant of a lot number 770-771-574 for area of land measuring about 3 Bigha 2 Kata. Again, as per land records of 1975-86, name of the petitioner of the instant case Srimati Gurguli Bormohan was recorded as tenant in place of deceased tenant Viren Bormohan. It has also been recorded that new DAG number 704 and 705 where the part of old DAG number 770 and 771. The petitioner was evicted from the DAG number 704 of 1688 new in the year 2014 as because the land record prepared after the resettlement operation where DAG number 704 old 1688 new is recorded as government land, not as a capital land where the tenancy was created. This is the tax.
after evicting the petition.
Therefore, after evicting the petitioner, one proposal was submitted by the circular officers body for allotment of the said land for establishment of family code, which is still pending. But as the matter is under the disposal of Honorable Guwahati High Court in WPC number 7, which is yet to dispose finally, an earlier order court has mentioned that petitioner is the legally recognized tenant of the above mentioned scheduled land. Further, the land here petitioner was evicted in the year 2014 from DAG number 704 and 1688 of village Paschim Bharat was originated from the DAG number 770-771 of village Paschim Bharat, where the name of the petitioner was recorded as tenant. Again, as per the provision of this Assam Temporary Supervisor Tenancy Act 1971, the recorded tenants are.
Yes, what is your stand in this letter?
After this letter, and there was an order passed by the Honorable Court, thereby, the Deputy Secretary of the Government of Assam Revenue Department has written to the Deputy Commissioner. And therefore, on the basis of that instruction, the report was confirmed from the circular. That I have annexed in my reply.
In this petition?
Yes.
Where is it?
They have not filed any.
In I figure
Huh?
3063 of the case.
3063.
There I have filed one affidavit. And paragraph 5 is the.
This letter. Where?
Paragraph 5. 87.
Of the affidavit of the
My affidavit in a function. Filed by Shamal Sector.
para 5, yes. Where is it? Ah,
As reported by the Assistant Deputy Commissioner Shamal Sector, the construction of
Mhm. para 5 of what para?
Para 4,
Para 4, which one?
Para 5, page 17.
It's 17, yes. Where is it? Where you are reading? That in regard to the state, governments made it para 4.
Again.
Ah, read it then.
Denying the same is correct. By reiterating, reaffirming the statement made in paragraph 4 of this affidavit in opposition, the repellent states that as reported by EDC Kamrup Metro, the construction of boundary wall has been carried out over a plot of land measuring 802.68 R, that is 59 giga 4 kata 10 lesser, covered by that number 704 old stroke 1688 new, which is recorded as government land. And the safe construction has been carried out by the state judiciary. And the applicant petitioner has no possession over the land. No construction has been done over the land claimed by the applicant under Khatiyan number 301, covered by that number 771 old 713 new.
Understood. What has happened pursuant to that letter?
Yes, the inquiry was conducted and then inquiry.
No, where the deputy commissioner writes to you. You see, deputy commissioner is not a small boy or a small post. He's the head of he's the head of the revenue district establishment. So he writes out here on the basis of some records, saying which record is that document is here in the I itself.
I also.
Yes, at page 9 of the I, wherein he says categorically in paragraph number 3 that as the matter is under the disposal of the High Court, which is yet to dispose of finally an earlier interim order passed, the petitioner is the legally recognized tenant of the above mentioned scheduled land. Further, the land where the petitioner was evicted in the year 2004, 14 from so and so was originated from old dark number 770771 of village so and so, where the name of the petitioner was recorded as a tenant. So you are saying
The deputy commissioner was saying something, but that is not based on record. The record was something.
Understood. No, court that how to resolve the dispute.
Yes. Thereafter,
What did you do in connection with this letter?
yes,
Because here he says that these particular originates from old dark number 770/771. I think this has to be something wrong out here. The reason why I'm saying this tag is tag number 7. First of all, on top he writes it wrongly. Kindly see. See the first paragraph. First paragraph of the same judge or the communication, he mentions that she's asking from 3 bigas 2 kathas 0 lesser covered by tag number 704/1688. Which is not wrong because it is absolutely wrong, as you can see from the application, that this is only done in respect to 730 and 574. 574/771 corresponding to 730. That is what has been done. Then the deputy commissioner writes it wrongly. Who is appearing for the deputy commissioner? Yes, what do you have to say there? You are the person who have caused all the problems. Then what to do? If I was a lawyer, it would have taken me 10 minutes to get it done. The way how to find it is this. You see, a cheetah when it is being made, or whatever it is being made, you will see initial tag number, and from that tag number, some other tag numbers are taken out. What happens? How do they take it out? They put 0, 0, 0, 0. The moment they circle it, Once it is circled out, this goes out. And which is not circled, it is in. These which are taken out when there is a partition of a big dark. When it is partition, it just comes out. And then for those zeros circled out, a fresh patta is being issued. Now, it is very difficult, or it is very, for this court to appreciate this aspect where he says that this particular dark number of 704-1688 new, which is the government land, originates from a government land that too measuring 68 bighas, originates from dark number 770/771. Here the Deputy Commissioner even doesn't know that if it is a government land, there is only a dark. And if it is a private land, it is a patta. The moment a patta is being issued, a patta may include many darks. There will be 70 darks or 80 darks or whatever it may be. Can there be 770-771 in patta number 1 also? In patta number 7 also? But your Deputy Commissioner doesn't know head or tail about the record of rights. What type of letters these people write? Or is he too busy in his administration to write such letters? And what have you done thereafter? You are sleeping over it, in spite of that 2 petitions pending, in spite of a contempt proceedings pending. Why you are sleeping over it? Why haven't you replied out here?
Thereafter, we have gotten another effort. That is page 20 of the file. We have written it to
Page
that page 20. We have written it
20 of what?
page 20 of my affidavit.
What have you written? Additional Deputy Commissioner has written.
No, no, page 20.
We have it,
Deputy Commissioner, right. Deputy-
Page 20. Yes. Yes. Deputy Secretary, with reference to the subject, I have directed to request you to kindly provide a detailed report as to whether the land in question is occupied by the petitioner or as the land claimed under the tenancy case of the petitioner, a boundary wall by any person or authority has been constructed. But this is not what we have done. This has nothing to do. What have we done pursuant to the communication of the Deputy Commissioner?
That is still not answered.
Then now I have got one teeth, the contempt. When in view of your admission of the Deputy Commissioner, I think the circle officer now has to be charged for contempt. Don't you think so? Where is the circle officer? Where is your contempt now? Whom have you made parties?
that time was Procedural, sorry about the,
You have made whom? Lokhinandan Sohoria. Who is he?
at the time he was the circle officer.
Your land is where?
Borough.
How does it fall in rural?
No, it's not. No, then at that particular time, when the contempt was passed, when contempt was committed, he was the circle officer in Guwahati. But when notice was served, he was transferred to the family. That is why we have to change the address. And the notice was sent to him.
Okay, but is he there?
Now he is not perhaps.
Then?
The circle officer is new circle officer. Where he has not been served with.
No. He may not be there now. But anyways, he has done the Mutation.
Yes, yes. He still remains.
Where is he? He's in Amingao.
No, not now. Perhaps not right.
Who is appearing for him?
Morigaon and toll Banaras.
Now, who is paying for him?
Anita Verma.
Oh. Call her. I think we should put him behind the bars. It's a contempt. Clearly. In view of your deputy commissioner's letter. Because the deputy commissioner says that that land falls from there. And the circle officer says something which the deputy commissioner is not saying.
There are when the report again comes up, that report says that the eviction was carried out, that is in respect of back number 1688, which is the dominant.
Understood.
Double it comes out
But
from
your
the-
deputy commissioner only said that these 1688 comes from the DAC number 771.
770-771.
Then,
When this scheme comes up with the cheetah,
then,
this is the next report which is coming up. This is on the basis of cheetah and we
it was such a simple matter, but your deputy commissioner has made it complicated. He doesn't know head or tail about anything.
If they produce the record before your lawsuit,
Record for what?
record for the read from deputy commissioner and say, he is doubting the. my
See, Mr. Songwa, this deputy commissioner doesn't know head or tail about how the land records are maintained. He's only there for the purpose of administration or holding all these events. These have nothing to do with it. They have no business of it. They don't know
My
anything.
friend has submitted that-
If they had known that this much, they would have known that every dag is a part of a patta.
Yes.
Why he has not mentioned that 701 and 771 in respect of patta number so and so? Or is it somebody else has written here, just put his signature as a rubber stamp? This seems to be what the deputy commissioner has done.
My friend has.
And your officers and the revenue department is very happy with such deputy commissioners who doesn't know head or tail. At least he should be knowing. Or if he doesn't know, why don't he allow the ADC revenue to do it? And don't touch manage events. He can do so. Nothing to do with out here. And why haven't you replied out there to that communication?
that is not yet.
Why? Means you don't think it important. Oh, it is only the circle officer who is only in the put into the is having difficulty. So why should we bother? But are you saying that the circle officer did it on his own?
No, when the
The
record,
circle officer did it on the basis of the deputy commissioners because he is the delegate of the deputy commissioner.
but the record which is originally is the circle officer is not for the whole record.
See, rule 18.2 is being exercised, but actually it should be exercised by the deputy commissioner. But-
The delegate.
But it is being delegated. So are you saying the deputy commissioner did not know it?
Not my submission.
And in view of that letter of the deputy commissioner, don't you think that the land has to be reverted if he has been evicted?
That is what I'm trying to say. Maybe
That is in respect of 7 bit.
Huh?
That is in respect of 7 bit.
I'm not concerned with 730 or 740. You say, your deputy commissioner says that that is the same land.
Later on, it's been clarified by
Where it is being clarified, there is no clarification to that effect. Are you saying that you are clarifying it by way of an affidavit? Why the deputy commissioner has not come up? Is he not a party out here?
Party.
Then why the deputy commissioner is silent out here after doing all the mischief?
75 Peckham says, but 574, 771 is the older, which has been newly compared as 730. Can they say that this is wrong?
Who says?
If my friend is saying that I have been evicted from, my dog is 730. But
See,
730
the
is a new dog.
simple thing would have been when the court has directed, or this matter could have been brought to a simple conclusion, but making a demarcation as to whether this
Yes.
land falls there, here or there. Better ends. It wouldn't have led to so many matters.
They can do it now even, if lordship passes it. They can do it now when we are ready to. Ready for
They
it.
will do it.
But they will not, I understand.
And the deputy commissioner has he filed an affidavit?
No, nobody has filed. In
No.
any of them.
You have not filed affidavits.
I thought the department.
You have filed in the IA. What are these IAs for?
I was there when they were constructing the boundary was there. We immediately approached.
There's a stay,
No, no other was there.
no stay.
No.
What boundary wall you have done? For what?
Boundary was by equity,
For what?
but the government act,
Which is this land? That Boragaon land?
Yes.
You break it. At the cost of your deputy commissioner. Of the costs which you incur it from the deputy commissioner. That is the only way out. Because the state cannot be put at loss because of the fault of the deputy commissioner. You undertake, Mr. H. Sharma, you undertake to pay the cost for this wall to the state. You undertake it. You have not filed your affidavits. Why? It's a 2014 matter. Then we fix it on 19th. On that date, if you don't file your affidavit by 18th, we'll impose the cost upon the deputy commissioner, as well as your commissioner and secretary. Both of you need to file your affidavit without fail. I don't know.
I think this document also, which my landed friend is relying on the deputy commissioner document.
I was saying it to be fake.
He is annexing it in the additional letter. So,
No.
I also.
In the IA also.
yes,
Then what is it?
so affidavit needs to file the affidavit in the
That you are to clarify in view of that letter. What steps you have, both of you have done. That is it. I don't require other things because other things are very clear. It is because of the fault of the deputy commissioner this has arisen. There is nothing else. Why? Tomorrow then. Tomorrow file your affidavit. I have spoiled a lot of time. You want an accommodation. 10,000 rupees is the cost to you.
I have a.
10,000. Oh, ask your junior to appear.
Yes, lordship is fixing on 19th.
No, dear. Ask your junior to appear out here. Let them file their affidavit. They are to only clarify out here. List the matter on list these matters. List these petitions on 19/9/2023 at 2 p.m. The Commissioner and Secretary, Government of Assam, Revenue and Disaster Management Department, Government of Assam, as well as the Deputy Commissioner, Kamrup Metro, are directed to file their affidavits clarifying their stand in respect to the communication dated 6/1/2022 issued by the Deputy Commissioner, Kamrup Metro, to the Commissioner and Secretary, Government of Assam, Revenue and Disaster Management Department. The said affidavits be filed by 18th of September 2023. It is made clear if the affidavits are not filed, this court shall draw appropriate presumption. Mr. H. Sharma appearing on behalf of the Deputy Commissioner, Kamrup Metro, is further directed to produce the copy of the Chita, copy of the Jamabandi, the record of rights, including the Chita pertaining to, including the draft Chita as well as the Chita pertaining to Dag number. Which one is the government one? Pertaining to Dag number 77. Your Dag number. What is your government one? 1688 old oblique
704 or 1688.
1704 as well as also the Chita as well as Chita, the draft Chita as well as draft Chita, Chita and the Jamabandi of Dag number 82. You have to do 730. Dag number 730 new. Other till 574 oblique 7 and 574 and 771 old oblique 730 new of KP Patta number 135 on the next. So, not what are you challenging in the second requisition?
There's a threat of eviction matter.
Huh?
Yes.
No, you are challenging two things.
Yes.
One is a office memorandum dated 10/1/2017. Where is it?
Because there is a threat. There is
Page 79.
Why are you challenging this?
my lord, in clause 9, my lord, and the page number 81.
So,
So in paragraph 18, it's stated, my lord, paragraph 18, paragraph 18, page number 70.
page number.
Yes.
So, what is wrong with that?
In page number 52, my lord, there is office number
Yes.
by the government, my lord. And it is- in the middle, my lord, the detailed guidelines for settlement of land for the people residing for long time in town, having a gain in this. In the middle, my lord. Deputy Commissioner identified the areas. Just before that paragraph, about recommendations to the committee.
But Mr. Nath, this is now being overshadowed by the land policy of 2019. As regards in the hill areas, more particularly in terms of clause 14.6, you cannot get
In
settlement.
terms of that, my lord, we submit some applications.
Understood, but now you cannot get a settlement in terms with clause 14.6, isn't it? And this policy, this office memorandum would lose its effect because this was made on the basis of the 1989 policy. Now that policy is no longer there.
So it's stated here, my lord, that 10% was there.
Mhm.
Case was pending, first case was pending, my lord.
Mhm.
What was there? So that they give a report by the committee and suggest to the government, my lord.
See, the only way you can, in this case, obviously, this is a different thing. It doesn't arrive. But 10/1/2017 can only be challenged if you challenge Rule 18. Without challenge to the Rule 18 and removing that Rule 18, the problem which arises after the amendment which have been made in the year 2019-97, you don't have a case. Then you are at the mercy of the government.
But yes, my lord, in my first case, my submission will be, my lord, if I succeed the first case, go to the second case, my lord, I never press the case.
But the first case to succeed
Yes.
is, can this court pass an order not to evict you from reserved land when the law is very clear as per the forest
On
regulations?
this point, my lord, I just want to make one submission.
Hmm.
I have gone for the judgment of the Samarbut court, in the, my lord, the Somota case also. In all these cases, the area mentioned there was the reserve forest, and the expected forest, my lord. Area 600 square kilometer, 500 square meter, 400 square meter. Here in my case, the land is inside the city of what? Area 70 hectare. That means 0.7 square kilometer. So here the institutional office for my lord. That area, such a small area, in 8 families, my lord. So there's a provision in the Land Conservation, Forest Conservation Act, there also regulation, 28, my lord. The government can take up the land from the central government. If I said promoted because
You want to de-reserve it. The only way it can be done is by de-reserving.
that's what, 28, section 28, and there's a judgment of the school also on this issue. Why I'm saying so, my lord, Dr. Francis, in those cases, elevate huge number of elements.
No, don't you think that in Guwahati we need a forest?
But about this, my lord, what the land, and what is served with the forest? In Kamakya, tigers come out, leopard comes out, my lord, in Kamakya, but it's not reserve forest.
Isn't it good that there is a leopard out there?
Yes, but it's not reserve forest. Here in my lord, small area only, in Kalapar.
So if the moment you leave,
0.7
then animals can come in.
That's why it's not elegant for you to write my mistake when I get with my lord. My lord is submitted by, I know my lord, I am absolutely cornered in this case. 8 families staying there.
By remaining
40 years,
cornered, you have been able to
40
survive with 15 years.
50, 40 years I'm staying there. And their income, whatever they earn in the lifetime, spent in the house of my lord. 8 families out of 13, 14 lakhs people living, what? 8 families not going to spoil that environment, my lord. I'm sure, my lord. That my lord is a sure, my lord. 8 families not my lord. Now there is a provision of reservation.
Mr. Nath, this question of sympathy may be good in front of some other judge. For this court,
Look,
I have
my
no
lord, I
sympathy.
don't press that much, I am pressing only because
Mhm.
in earlier all these cases,
Whatever may be, there is
600 families.
no forest, nothing. There is no way unless it is a case of de-reserve.
Yes,
And why
my-
should they de-reserve it?
Because
In
my lord,
Guwahati now, if we look into it, we have no proper forest area. There is a lack of oxygen because of this.
but my lord, 0.7 square kilometer is falling under what is and limit them.
They are trying to make further areas as forests now.
70 hectare, my lord, in the notification, there's 34 in the application. 70 hectare means 0.7 square kilometer, such a small area, my lord.
No, therefore, the question is, did you file any application in prior to 1989? Did you?
No, my lord.
Then
Because
why didn't you claim it then?
It's
Then
because
don't reserve it.
in my
You
petition
see
also-
that those proceedings which are being initiated at that point of time under section 3, 4, and 5 makes it very clear that if you have an objection, you could have very well raised it. Why haven't you raised it then?
My lord, in my petition, I have stated, my lord, they have not followed regulation 5 and 6 properly, my lord.
You have not challenged the proclamation.
Proclamation, here I have stated, my lord.
No. Mr. Unless you challenge the proclamation, and that too more particularly when the proclamation has been in existence from 1989, why should this court at all interfere?
My lord, that's why I said in this case, I'm just thinking about this case, and it is like, I'm absolutely honored in this case. That's not how float out of in this case, my lord. That's why, my lord. This 0.7 square kilometer, and in 1 minute is going to spell
The
that-
only sympathy this court may have is say some words of solace, nothing more than that.
Now, my lord.
But
that's
not
why
in
I'm
a, but
coming, my lord.
that
Is
too
it
not in a
possible, my lord?
judgment.
My lord, I just last submission, my lord. Is it possible? Under regulation 28, power to declare forest no longer reserved. This is one provision, and Forest Conservation Act also, like section 2 says, my lord, that in this situation, because this situation 8 family, my lord, can the government take up the central government, my lord, as per the act, if the dismiss my case, let them do, my lord, in the direction of no report, just to state this, my lord. Upper can do nothing to say.
That is absolutely there within their domain.
So, Lordship, can they, if it falls from your lordship's my lord side, my lord, if they
No.
can consider, my lord. I
This
can place
court,
the
this
lordship's
court does not do anything to that effect. I am very clear on my right, my authority. My right and my authority is not there to touch on what they want to do. If there is a transgression upon your right, obviously I will interfere. Now show me if there is a transgression upon your right. What right do you have to remain in a reserve? Because you see, Mr. Nath, the main problem is you can't give the final relief. What you are asking not to evict you, in view of that, whatever has been mentioned in the earlier order passed by Justice Biswas. That relief, they have done something. That is another aspect of the matter. But at the end of the day, you cannot be settled there. There's no way out.
Lordship,
There might be a settlement as regards the remaining
my
7.
lord,
Remaining 7, they may give a settlement as it is a common land, they may give some settlement. But as regards the number 8, there is no way
your
out.
lordship is 7% right, my lord. I'm
Hmm.
not with them, my lord. Only
Then-
my submission, since there are two provisions, section 3 of the Conservation Act and 28 of the regulation, there's a provision, my lord, because each case is decided on its own merit, my lord. In both cases, my lord, 600, 500 square kilometers, yes, 0.7 square kilometers, small part of that, my lord. So if the government can take it, central government.
Are you going to say the massacre of 50% cannot be condoned and a person being killed is can be condoned?
My lord, 12 lakhs people are.
It is one and the same. It is one and the same. The moment you are there in the forest, reserve forest, no rights. Matter
My
ends.
lord, that part, I am 100%, I'm sure to meet you, my lord, I am with the lordship, my lord. But
No.
only that part, my lord.
You see,
If they can consider. other
no,
sections-
Mr. Nath, you may request the forest, the central government, you may request the state government to consider 3 or 28, that is their lookout. But for this, there cannot be any order passed by this court to give you any protection. The governments are nowadays very lenient. They think you may have another 5, 8 family with around another 4 staying, 32. 32 makes it 32 important votes. They may think about,
My lord, to be very honest.
but not this.
Since last 3 days, my lord, she won't believe, my lord, only one thing is passing my mind. Last 3 days about this case, I'm just thinking,
Hmm.
all these people are living there, how these 3 families and their money gets spent, their house, where they will go, my lord. I got personally got discovered in this case, my lord. To be very honest, my lord. That's why I say, my lord, if something in direction, let them look in on the road 28 or section 2 of the Conservation Act, my lord. Let them look into it, switch my case, my lord. But still there, that will be there, my lord. That's my permission, my lord. I have got nothing to say, my lord.
Mr. Nath, you have been thinking only for the last 3 days. I've been thinking from 23/8/2023. What to be done with you?
My lord, I know, my lord, all the available court, whenever this is lifted, they have got sympathy with me, my lord.
I don't have- Sympathy doesn't place good
My
with
lord,
us.
that's why, my lord, there is repeated directions, my lord, to organize the plot of land, my lord. At least there's the let them come forward and say to your office, my lord, there is no plot of land, what? That plot of land.
Only-
One thing, my lord.
Mr. Nath, only thing I can say that you are very unlucky to be there before this court. When this court has taken up the matter.
No, I think.
Because otherwise, the other courts have some sympathy. I don't have any sympathy.
I don't mean that, my lord. I'm sorry, I didn't mean that, my lord. Your lordship is
Mr.
completely,
Mr.
this is not a different issue, but I know your lordship, my lord. That's it. Not at all, not at all, my lord.
Yes, Mr. Nath. The other Nath, what do you have to say? How do you take care of him, these people? This court is not going to stay any eviction in respect to the forest area. There's no question of that. But how do you take care of these people?
So, as such,
Being a welfare state.
I am returning,
I mean,
I have, there is no such scheme at this stage, give some benefit to the enclosures of the forest.
no, there's no scheme. But the thing is,
But that is for the government, not I.
no, this is absolutely within your realm of consideration, which I am not going to interfere. But what can be done for them? Thinking about they have been there for years and all. Yes, you have not been able to evict them for, there are litigations from 2008 onwards, for which you have not been able to do that. But at the end of the day, you see, the problem arises here. These are one petition. There are two sets of petitions. 7 falls outside forest, 8 falls inside forest. For 7, this court would permit the state to consider their applications until the consideration is done, not to evict them. How does this court take into account as regards the 8? But this court is not going to pass an order as regards 8, not to evict. But how do you come up with what is the reasonable thing which can be done? So that at the end of the day, Mr. M. Nath can leave the court a bit with a smile, maybe a frowning one. But with a
I don't, and I always go in my right, in every case, my lord, whether my favor or against me, my lord. I maintain that, my lord. In fact, that is why the commissioners, said, well, the reservation can always see, well, that is something. But I don't know, it is absolutely.
No, those reservations, no. This court is not going to say anything on those. And I'm not going to regard this. If they want to do, they are at liberty to do whatever with the state. The state, the moment, I am only confined to the brief which is before me. As regards the de-reservation or whatever the state wants to do it, let the state do it. And that might be a subject matter of a PIL, which the state should not have done it.
It is not their case. It is not there.
They are banking upon that order of 5-6.
Order of 5-6, and without taking necessary steps, as per the order, it is 15-6-2007.
That is it.
Ultimately, now record reveals that it has been the exercise has been done, and they are found to be inside the policy. But Somebody, we should not, if we will brief on at this stage, in absence of the policy, it is very difficult for us to get to leave something. Because these are matters of policy decision.
No, I am not asking with the state to give anything. No, I am asking you as a lawyer, what can be done? As a lawyer, I am asking you.
There will be given some, instead of 1 month, 2 months.
This court is thinking about 60 days. That too 60 days. But what to do in the meantime? What to do? How much area they are occupying? How much area, Mr. Nath? You are occupying?
Each pigeon had seen around 1.10, 1 kata 10 lesser or 2 kata.
All the petitioners. All the petitioners. No, no, all the petitioners.
All the petition like that.
One katha, 10 lectures.
They're not like that. I check up that one. Some are in a position of. There are already where it is 2%. Each of the.
Where can I get that?
Requisition minus 1746. There minority will come to 856.
Huh?
856.
Page 66. Yeah, page 66.
Second petition, my lord. Second petition.
Page 56. Yeah.
Part of the application seeking settlement of that.
Hmm.
There case is minority fine, the affidavit has to be submitted. That is in opposition of 2% letter.
Next is also 2.5. Next is 1.1 cut of 5%.
Application minority fine at 365. This is of minority.
5% submitted.
Down because multiple finance
65?
55.
55. Yes.
55. 55 is the application for settlement of land.
Hmm.
They are at serial number 19, minority finance. Serial number 19. Particulars of the asset, if enclosed, since when? 1975-86. Of 6 down below is the signature. Down below is the signature, it is a declaration.
Hmm.
Says that I hereby declare that the statement. So this is the admission.
Hmm.
This is the admission that they are enforcing. Now, if an argument is coming from that side, on an earlier point of time, this honorable court has directed for constitution of the committee, and that committee will look into that, that he will fall down in view of this declaration, because he himself will declare. So that means he has that way, he has waived his right. That may not be spinning up from that order. I have waived my
No,
right.
no. You see, what can be assumed from that order? The order may have stated many things, but whatever may be, a direction was given to the state, headed by the chief secretary, to look into as to whether the dispute can be resolved. And till that dispute is not resolved, nothing is to be done. What the court did on 15/6/2007 or 8 is continuing. You must have done something. And day before yesterday, I put the same question to him. Instead of disposing of the repetition in a similar matter, I put a question to him, what can be done? So he has come today and said that nothing can be done to that effect. So that is it.
So, admittedly, on record,
Because anyways, this court's direction, if it is passed without taking into account the section 6, which is the proclamation, and saying that where proclamation is made, no rights can accrue. Any order being passed without taking into account that would be per inquiry.
so therefore, their entry into the reserve forest itself is what a issue. That is illegal. By virtue of minor operation, regulation 4, 5, and 6.
So their entry into the reserve forest may or may not be void ab initio because of the fact that they claim that they have entered in 1987.
Yes.
Because in 1989, the proclamation came. So one cannot say to entry on void ab initio. But because of the proclamation under section 6, if I am not wrong, no rights can accrue upon them. And if no rights can be accrued upon them by virtue of a provision of the Act, until that provision remains, this court cannot confer a right by way of a writ. This is my simple understanding of law.
Because yes, because that exercise was undertaken prior to 1989. 1989 is the culmination of the process. Consider see it over earlier. It started in 69. They came in between. Now, in between section 7 comes into operation. They had every right to file objection. They did not.
What do you do with the A7? With the 7, 8 reserve. 7, we have 15 petitions. What do you do with the 7? They have already filed applications. All the petitioners they can file for other lands. Why should I say for about other petitions? About the 8? No. 7 are not in forest. So they may be entitled for a settlement. You may give a settlement to them.
Correct. Otherwise, also by the MP or occupation in a government zone itself is because in 080.
Mr. Nath, you need to challenge them. Yes. I've been telling everybody to challenge. I hope Mr. Arbor tells someday to this court, not before this court. Yes. Yes. No. This is as regards Rule 18. Rule 18, what has happened initially, when it was there, it was only confined to 3 types of lands: roadside reservation, grazing, and another land which cannot be settled. Now they have brought in wasteland, which is a land which can be settled. By after Radha Kanun's judgment, they have brought in 1997. Now nobody has challenged that. That is the reason why everything is happening. That is a different thing. PIL does not, there is no res judicata. Yes.
That's why so far those person petitioner who are outside the boundary of the forest. Yes, they can make an application.
No, they can, the others can also file applications and which they have already filed, which is there on record. So these petitions, they may not be entitled because as per your extent policy of 2019, a person is not entitled to, he cannot claim that he has to be given a settlement in the land where he is in occupation. He has no right on that. You may consider it in some other place to give it to him. That is your lookout. So everybody, even the person who are in reserve forest can claim a settlement on the basis that they don't have any right over the land. That is only the eligibility criteria, that he or his family should not have any right over any land. If they don't have any right over the land, they may claim. So they can very well file those applications for that. But for reserve forests, you cannot touch. But what about the others? Till the disposal of the applications, these people needs to be protected because you have not done anything against them for that. But for reserve forest, this can't. Huh? Why should I say all these things? This is none of my business to say. Yes, you disposed. Yes.
Yesterday, in one of the report, it says 9 are outside. But she needs to be in one report says inside, one report outside. So Roshni said that Roshni will hold this at the outside.
No. I am not going to say who is outside or who is inside. I will say those people who are in the reserve forest has to be evicted. No rights can accrue. But as regards the others who are not in reserve forest, they have they are not to be evicted till the disposal of here, giving you liberty to, as regards to the 15, to file applications afresh, and the authorities shall duly consider the earlier applications also so filed for the purpose of consideration. That is it. But as regards the 8, no eviction. The eviction, no stay. Yes. For 7. Those who are outside for 7, till representation, that applications are disposed of, nothing is to be done. But as regards the 8, no stay. You may evict. I'll pass the order today. You produce, you give the records. You do my record photo. Oh, you got that order?
Yes, I have 2 orders, ma'am.
Here, my lord, can take a criminal justice.
Oh, 30 days. 30 days.
There are 2 others, madam. One, specifically the PIL, and these are SPSC people who have been taken to the forest. They are, madam, they write to, it was dismissed and it was actually evicted. And other, madam, these are forest villagers who were brought in by the forest department. When they saw, madam, those are typical forest villagers. 61 square kilometers.
It's okay. You see, this is not the thing which this court has a different opinion. It is in, you give me, you have the records. You give me these 3 documents. One is the first notification under section 3. Then another declaration which has been made in section 4 and the proclamation made in section 5. That proclamation which happened on in the year 89. These 3 documents, you just give a photocopy to him. Today. Just now. I'll pass the order in evening. These are disposed. I'll give a copy of to you and him for necessary compliance. Huh? I'm giving them 60 days. 60 days they may vacate, else the authorities will take necessary action.
Can you make it longer? Because they are
Huh?
structure, everything is there. Little more build up. Since they were not 40 years to stay, my lord. And they entered the 40 years. That's why 60 days and 90 days doesn't make any difference. Maybe little longer.
At the,
Because this is the urban trade of Guwahati, ma'am. Had been a petition from Dhubri or Morika, ma'am, no protection.
why?
Because this Guwahati, ma'am, they is saying that what with this do, but normally we have power over instances, ma'am, use and use plots, where even one single person is not entitled.
Understood, he is not entitled, but the thing is,
Say that 60 days documents, that is judicial thing.
okay, let it be 90 days. As you have already waited for 15 years. Isn't it?
In this case, should definitely 15 months.
Huh?
No, my lord.
So,
Number 32, 33.
Yes, Mr. Chaudhary, what do you have?
But I propose to do. Possible is for openings at this stage. I'm not praying for it. My only prayer is, my lord, let them find their reputation possible within 2 weeks, let them find it. Because we have.
Because anyway, this way or that way, you need an early disposal of the
Yes,
matter,
yes.
not for the purpose of the work.
Yes.
Because for the purpose that you may have to go for arbitration, which may delay.
Yes, that's why, madam, my lord, what you have asked for, also more, there is a recent judgment of the Supreme Court. That is, my lord.
In fact, Mr. Chaudhary, that judgment which I have given in your case, remember
Yes.
that arbitration matter,
Ah.
where I have said that no, the writ cannot be issued, although I have dealt with why it cannot be. And I have dealt with each and every recent judgment. This is Indra Banerjee's judgment, the latest one was there.
Wealth fund specialty.
Huh?
Wealth fund specialty. It's a reported case of 2022.
Yes, I've done it.
So that's why there is no pleadings in support of this. The proposition is, my lord, when there is a provision for extension and imposition of litigated judgment, then my lord, the question of, my lord, the time being the essence of the contract.
But what do you say about paragraph 3 of the termination notice, where it has been given, stated out there that on 16/7/2022, You were given a notice of termination and thereafter you continued out there.
No, no, that is there. And the one more aspect is, madam, there is one more point, that's why I thought, my lord, I will get the notice. And the lordship will kindly ask them to file their application. Lordship will take a final call.
Okay. But pendency shall not bar them from going ahead with that.
Lordship may not say anything, my lord, if they want to proceed, let them proceed. I think I'll have to file an additional affidavit also, my lord, to bring on record that.
Mr. Chaudhary, can you were there with Mr. Nilanjan Deka, I suppose that matter?
That, my lord, NRL matter.
That was an NRL matter, no? Where Mr. P.K. Tiwari and R.J. Das was there on the other side, where they had made it. I said that I can't issue in view of that. And there I have taken into account the latest of the judgments, even after Justice Indra Banerjee's judgment, where Justice Indra Banerjee's judgment don't touch it. But thereafter, there is a judgment of our Chief Justice of India, wherein he says that these are the facts where it can be touched. That also have dealt.
Yes.
I forgot where I left it.
Altogether, it cannot be touched.
It is not altogether. Because there is always a, yes. But there in that case, it was not so. If you notice, making it returnable by 4th of October 2023. Mr. K. Kulta accepts notice on behalf of the respondent number 1 and 2. And you are appearing for net fee? Mr. R. K. Batra appears on behalf of the respondent number 3. As all the respondents are duly represented, extra copies of the petition be served upon them by 15/9/2023.
Tomorrow, we will pick up.
Tomorrow is 15/9?
Yes.
15/9/2023. The respondents shall file their affidavits by 3rd of October. The respondents, what is the role of NETFI? Then I make it. That is okay. But otherwise, they have nothing. For the purpose of this case, I think respondent number 1 and 2. The respondent number 1 and 2 shall file their affidavit in opposition without fail by 3rd of October. I'm not concerned with other way. This only there you have not filed. File it. But they have challenged the termination. So you have the time, you file it. Mr. K. Kulta appearing on behalf of all the respondents submits that he would file the affidavit in opposition by 29th of September 2023. With advance copy being served upon the petition. The petition will be at liberty to file their reply by 3rd of October. Mr. Chaudhary, I fixed these dates only for the convenience of the councils. But what happens, the councils, they don't understand. If they don't understand, what is there? Because when I was a lawyer, it was very difficult to get a matter listed or heard. And that is the reason why I take the very pain out there for fixing the dates. So that it happens, something is done. Okay, put.
I don't know, sir.
Mr. Dasgupta, I troubled you, although your instructing counsel is not well. He has some, what you call it? Yes, he's in bereavement. But the thing is that matter has been heard at length. On the last occasion, I had asked them what has happened. Has any development happened? Where is Mr. Nath? Where is he? Mr. Nath, what has happened in the meantime? Anything?
So the presently the assembly session is due month.
Hmm.
Yeah.
No, you see, the problem arises as of now because you have not done anything. Unless something is shown to this court that you are in the process of, you have only stated that you are going to do it, which you have not done it, so it can't be believed. But unless you show some process, then only I can refer to those judgments of the Supreme Court, wherein if a process is there. There were some judgments somebody placed, I forgot. Where are those judgments? Yeah, judgment decision. There were 2-3 judgments which were placed. I think by Mr. Dasgupta, you placed 2-3 judgments wherein it says when even the draft rules can be taken into account. But draft rules can only be taken into account when you see in near future they are going to do it. But if you don't do it,
Yeah, the position of civil, I can take it. Over telephone, I can take it because we were meeting the assembly.
you just take that because then only this court can do something. Because there seems to be no urgency. Because this matter only I'm keeping it. Otherwise, I could have disposed it of out here. Because 2 of the persons is already more than 75 age, so that can be very well taken care of. But as regards the other person, he has already been joining. He will be only entitled to his back wages, which have not been paid. There is a stay. So that he is obviously will be entitled for. So that I can very well dispose of. I'm keeping this matter only pending because of your what needs to be done, because this is a very important issue which needs to be done in respect of those industries which does not have a standing order as regards the age of retirement. That is the reason why I'm keeping it pending.
Considering in fact, one time, he expressed his seriousness that will be there. Whatever.
So what process has, what development has happened, that is the only thing. That is why I didn't adjourn the matter, only to get that in. You do one thing, what you have mentioned out here na, in the additional affidavit, that you are in the process.
Paragraph 5. The government is considering
Brought into force, the proponent begs to state that Azhar has not yet been brought into, however, is considering the at the earliest possible. So this was filed on 21st of August.
Yes.
Let me fix it after Puja. And in the meantime, let's see what happens and file an affidavit. I think the reason why I'm fixing it after Puja is so that something happens. For disposing of the matter is no problem. But if the moment I keep this matter, something is happening.
correct, because of this case only it has come.
Yes. During the course of hearing, this court had had inquired with Mr. Dina, the learned senior government advocate, as to what is the present status of the Assam Industrial Employment Standing Order Amendment Rules 2005. In as much as in the paragraph number 5 of the affidavit filed by the Principal Secretary to the Government of Assam, Labour Welfare Department, dated 21/8/2023, there is a mention that the government is considering to process the draft rules for finalization at the earliest possible. Mr. S. Adinath submits that the site process is on, but some more time would be required to bring the said process to a logical conclusion. Taking into account the importance of the issue involved, this court fixes this matter again on 7th of November. In the by 6th of November, by 6th of November 2023, the Principal Secretary to the Government of Assam Labour Welfare Department shall file an affidavit bringing on record as to what further steps have been taken and as to whether the draft rules have been notified. List according.
So, if orders are ready.
You want that I should allow the requisition, but giving him 15 days.
Is sending it affidavit.
The instant writ petition has been filed by the petitioner, challenging the no confidence resolution dated 26/6/2023. Whereby in the special meeting which was convened a resolution of no confidence was passed against the petitioner. It reveals from the record that this court, by an order dated 28/7/2023, had issued notice, and in the interim had stayed the resolution dated 26/6/2023, held in the special meeting of 14 number Ranighat Gaon Panchayat, as well as also the communication dated 26/6/2023 issued by the Executive Officer, Sonai Anchalik Panchayat to the Deputy Commissioner Kachar till the next date. The said interim order, so passed on 28/7/2023, was directed to be continued by an order dated 28/8/2023, and the same is in operation. This court further finds it relevant to take note of that the private respondents, that is the respondent numbers 9 to 17, have also filed an application seeking vacation of the order dated 28/7/2023. Mr. K.P. Pathak, the learned counsel appearing on behalf of the private respondent, submits that the said contents of the said application be treated as a part of the affidavit, be treated as the affidavit in opposition of the private respondents. In the backdrop of the above, let this court therefore take into consideration the issue, the facts, as well as the brief facts, as well as the issues involved herein. The case of the petitioner, as could be seen from the perusal of the writ petition, is that the petitioner was elected as the president of Ranirghat Gaon Panchayat, for short referred to as the Gaon Panchayat in question. It was mentioned in the writ petition that 6 numbers of group members of the Gaon Panchayat had submitted a requisition notice before the executive officer, Sonai Anchalik Panchayat and the development block on 9/6/2023 for convening a special meeting of no confidence motion against the petitioner. On the basis of the said requisition notice dated 9/6/2023, the president of Sonai Anchalik Panchayat decided to convey it is relevant to take note of that the said requisition notice dated 9/6/2023 had been enclosed to the writ petition as Annexure 1. Next. It is further relevant to mention that the president of the Sonai Anchalik Panchayat decided to convene a special meeting on 26/6/2023 at his office, and as such a notice dated 21/6/2023 was issued to the concerned group members. It is the allegation made by the petitioner that such notice was not served upon the petitioner. In advance. The petitioner, however, came to know about the requisition notice dated 9/6/2023 from some other sources, and the petitioner submitted a representation dated 26/6/2023 to the secretary of the Gaon Panchayat in question, whereby the petitioner raised his concern of violation of the mandate of Section 15 of the Act of 1994. It further reveals from the records, and more particularly, Annexure Roman 3, which is the minutes of the special meeting of the Gaon Panchayat in question, held on 26/6/2023. In the same minutes, it is seen that out of 14 members, 14,
Out of 10 members. Out of 10 members,
out of not 10, 11. Out of 9 members present, all the 9 members voted in favor of the no confidence motion against the petitioner. Thereupon, on the very day, the executive officer Sonai Anchalik Panchayat issued a communication to the Deputy Commissioner, Kachar, forwarding the resolution dated 26/6/2023. For necessary information and action. It is on the basis of the said above facts, the petitioner being aggrieved on account of the infraction of the rights under section 15 of the Assam Panchayat Act. Assam Panchayat Raj Act or what?
Assam Panchayat Act. Assam Panchayat Act.
Assam Panchayat Act 1994. For short, the Act of 1994 has approached this court challenging the resolution dated 26/6/2020, 26/6/2023, as well as the communication dated 26/6/2023 issued by the Executive Officer Sonai Anchalik Panchayat. This court further finds it relevant to take note of the application filed by the private respondents, which have been registered and numbered as IA C2552/2023. As already noted, supra, the learned counsel appearing on behalf of the private respondents have requested this court to treat the said application as the affidavit in opposition of the private respondents. This court deems it proper to deal with the pleadings contained therein. Taking into account that the instant dispute pertains to as to whether there has been any infraction to any violation to the provisions of section 15 of the Act of 1994. This court finds it relevant to limit its consideration to the extent of the dispute involved. There has been, in the same interlocutory application, there have been various allegations being made against the petitioner. Of misappropriation of amounts to it has been mentioned that the private respondents have prepared a requisition letter on 1/6/2023 and went to submit the same to the secretary of the Gram Panchayat. But both the president as well as the secretary of the Gram Panchayat were repeatedly found absent in the Gram Panchayat office due to fear of giving explanation to the applicants, the private respondents, about unauthorized withdrawal and misappropriation of the Gram Panchayat fund, for which the private respondents could not submit the said requisition notice. Ultimately, finding no alternative, on 9/6/2023, 6 applicants, that is the respondent, the private respondent numbers, 6 of the applicant, who has given it?
Then gate number 3, I give the respondent.
The respondent numbers so and so. Applicants been the respondent numbers so and so, who are 6 in number, submitted a requisition notice to the executive officer Sonai Anchalik Panchayat and Development Block for convening a special meeting of the no confidence motion against the petitioner, which falls under the Sonai Anchalik Panchayat. It was further mentioned that on receipt of the said requisition notice, the executive officer Sonai Anchalik Panchayat forwarded the same to the secretary of the Gram Panchayat in question for taking necessary action in that regard. This aspect can be seen from Annexure D to the said application. It was further mentioned that on 12/6/2023, the secretary of the Gram Panchayat in question was found available in his office, and in response to the said letter dated 9/6/2023 issued by the executive officer Sonai Anchalik Panchayat, the secretary to the Gram Panchayat, by the communication dated 12/6/2023, informed the executive officer Sonai Anchalik Panchayat that he has no any communication with the petitioner for more than 1 month, because the petitioner did not receive his call, nor that the petitioner neither received his call nor called him back. It was further mentioned that the secretary of the Gram Panchayat had tried to contact the petitioner for taking approval under section 15(1) of the Act of 1994 to conduct a meeting, but failed to contact the petitioner. The further perusal of the said application shows that thereupon, the president of the Sonai Anchalik Panchayat issued a notice on 21/6/2023 for holding the no confidence motion meeting against the president of the Gram Panchayat on 26/6/2023. Against the petition on 26/6/2023, giving intimation to all concerned, including the petitioner. It is further mentioned that on 26/6/2023, the no confidence motion was held under the chairmanship of the president of the Sonai Anchalik Panchayat, and the voting was held in a secret ballot. And in the said meeting, 9 out of 10 members of the Gram Panchayat had cast their vote in favor of the motion, and the writ petitioner was removed from the post of the president of the Gram Panchayat in question. It was further mentioned that pursuant to the said resolution so adopted on 26/6/2023, the executive officer of the Sonai Anchalik Panchayat had informed the deputy commissioner about the resolution dated 26/6/2023. This was followed by another communication on 21/7/2023 whereby the Chief Executive Officer of the Kachar Jila Parishad forwarded the proceedings of the resolution adopted against the writ petitioner on 26/6/2023 to the Deputy Commissioner. Resolution adopted is to the Deputy Commissioner, Kachar, with a request to allow the Vice President of the Gram Panchayat in question to discharge the powers and functions of the President of the Gram Panchayat in question as per the provisions of Section 13(2) of the Act of 1994. However, the Deputy Commissioner, Kachar, did not take any steps in terms with the communication dated 26/6/2023 of the Deputy Commissioner of the Executive Officer, Sonai Anchalik Panchayat, as well as also the communication dated 21/7/2023 of the Chief Executive Officer of the Kachar Jila Parishad. I've heard the learned counsels for the parties and perused the materials on record. The dispute which is involved in the instant writ petition is as to whether the action on the part of the respondents are twofold. First, as to whether the no confidence, whether the resolution so adopted in the meeting on 26/6/2023 was in accordance with Section 15 of the Act of 1994. Secondly, as to what relief the parties herein are entitled to. Up next. For the purpose of deciding the first issue, this court finds it relevant to take note of Section 15 of the Act of 1994. In terms with Section 15(1) of the Act of 1994, it is clear that every president or the vice president shall be deemed to have vacated his office forthwith when the resolution expressing want of confidence in him is passed by a majority of 2/3 of the total number of members of the Gram Panchayat. The manner of holding the meeting has been stipulated in the first paragraph of subsection 1 of Section 15. It stipulates that such a meeting shall be specially convened by the Secretary of the Gram Panchayat with the approval of the President of the Gram Panchayat, and such meeting shall be presided over by the President if the motion is against the Vice President, and by the Vice President if the motion is against the President. It is also the clear stipulation. It is also a clear stipulation that in case such a meeting is not convened within a period of 15 days from the date of receipt of the notice, the Secretary of the Gram Panchayat shall within 3 days refer the matter to the President of the concerned Anchalik Panchayat, who shall convene the meeting within 7 days from the date of receipt of the information from the Secretary of the Gram Panchayat and preside over the meeting. Therefore, the words, the date of receipt of the notice, inverted comma, words, the date of receipt of the notice, words, within a period of 15 days from the date of receipt of the word notice. And again, therefore, the words, within a period of 15 days from the date of receipt of the notice, inverted comma, means that the said notice has to be served upon the president of the Gram Panchayat. And the right of the secretary of the Gram Panchayat to refer the matter to the president of the concerned Anchalik Panchayat will only arise after the period of 15 days of the date of receipt of the notice. In the present facts, it would be seen that admittedly, the same requisition was dated 9/6/2023, was not served upon the petitioner. It is further seen from the requisition itself that it was addressed to the executive officer Sunai Anchalik Panchayat and Development Block. The executive officer Sunai Anchalik Panchayat, upon receipt of the said requisition, on the very day issued a communication to the secretary of the Gram Panchayat in question with a copy to the vice president of the said Gram Panchayat. It is not known as to when the said communication dated 9/6/2023 issued by the executive officer of the Sonai Anchalik Panchayat, wherein the requisition was enclosed, was received by the secretary of the Gram Panchayat in question. But one can assume that as on 12/6/2023, the secretary of the Gram Panchayat in question had noticed about the requisition dated 9/6/2023. In the communication dated 12/6/2023, it has been mentioned that the secretary of the Gram Panchayat in question had no connection with the petitioner for more than a month. Which clearly shows that till 12/6/2023, the requisition dated 9/6/2023 could not be served, was not served upon the petitioner. It is, however, relevant to take note of that the secretary of the Gaon Panchayat in question did not wait for a period of 15 days from the date of receipt of the communication requisition dated 9/6/2023, which was forwarded by the executive officer of the Sonai Anchalik Panchayat. But on 12/6/2023 itself, informed the Anchalik Panchayat that he could not serve, that the secretary could not serve. The notice upon the petitioner. The issuance of the notice on 12/6/2023 by the secretary was a clear infraction of section 15(1) of the Assam Panchayat of the Act of 1994, in as much as the secretary could have exercised the said authority to refer the matter to the Anchalik Panchayat in question only after the completion of 15 days from the date of receipt of the notice by the president. Taking into account the same, which as per the well-settled principles of law is a mandatory provision, the holding of the meeting by the petitioner, holding of the reference so made, taking into account,
Taking into account the same, which as per the well settled
principle
of
are
law.
mandatory in nature. The reference so made to the Anchalik Panchayat by the secretary is bad in law. And consequently, any action taken on the basis thereof also becomes a nullity. Next. In the backdrop of the above, let this court therefore take into consideration the second point for determination as to what reliefs can be granted to the parties herein. As already observed herein above, as the reference made by the secretary on 12/6/2023 was in violation to section 15(1) of the Act of 1994, the holding of the convening of the special meeting by the Sonai Anchalik Panchayat and the consequent resolution adopted on 26/6/2023, as well as other communications issued by the authorities, are nothing but non-est in law, for which the impugned resolution dated 26/6/2023, as well as the communication dated 26/6/2023 issued by the executive officer Sonai Anchalik Panchayat to the Deputy Commissioner Kachar, are all set aside and quashed. Be it as it may, this court also finds it relevant to take note of that there is a requisition being made by some of the members, by 6 members of the Panchayat in question, seeking a no confidence motion and making a requisition for a special meeting to discuss the no confidence against the petitioner. As already stated herein above, the petitioner have enclosed the requisition at Annexure 1 of the petition. And as such, the petitioner has due notice of the said requisition. Then, and it may be deemed that as on today, the petitioner has notice of the deemed requisition, of the requisition dated 9/6/2023. Taking into account the above, this court now it is therefore the opinion of this court that as on today the petitioner is deemed to have notice, the petitioner is granted the liberty to hold the meeting, convene the meeting of no confidence, convene a special meeting. I've said, no, he won't. He has to give the permission. He has not given his permission till now. He's given the liberty to grant the permission within 15 days from today. That is by today, how much? So by 30, today is gone, na? 30. By 30/9/2023, for convening the special meeting. For discussing the no confidence motion against the petitioner. In terms with the requisition made on 9/6/2023. It is made clear that if the petitioner does not exercise the liberty so granted by this court within the time stipulated herein above, that is by 30th of September 2023, the secretary of the Panchayat in question, who is the respondent number 9 herein, 8 herein, shall do the needful in terms with the provisions of Section 15 of the Act of 1994. With the above, accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. Number 1, the impugned resolution adopted on 22/6/2023, 26/6/2023 in the special meeting held at Sonai Anchalik Panchayat, in the office of the President Sonai Anchalik Panchayat, as well as the communication dated 26/6/2023 issued by the executive officer of the Sonai Anchalik Panchayat to the Deputy Commissioner Kachar are set aside and quashed. Number 2, the petitioner is given the liberty to grant the permission for convening the meeting of the meeting, convening the meeting, requisitioned by the requisition letter dated 9/6/2023 within 39/2023. It is made clear that if the petitioner does not grant the permission within 39/2023, the secretary of the Gram Panchayat in question, that is the respondent number 8, shall do the needful in accordance with section 15 of the Act of 1994, thereby bringing the requisition so made, right, 1980. With above the instant petitions as disposed.
There were 17 activities, also 17 applied for and he was awarded 3 packages, that is 4, 11, and 15. While issuing the LOA, there was a change of
Why there are so many matters? All are by the same petitioner.
In respect of package number 4, 11, and 15, and 2 others are different petitioners and 1.
You are paying for all. So now, what is the point involved?
It's actually all of them are.
Okay.
There was a revision in the payment continuum. First of all, I will take the lordship to the case 26 of the NIP.
Yes.
The supply direction, testing and commissioning of works, progressive work supply. That 1.1 is important item. First, it's almost 60%. 60% payment against the supply of various items of price. One, complete items of individual solar home lighting system, including 100% salary, paid or received and acceptance of the materials on submission of the documents indicated herein. When the petitioner was given the package against the 4, 11, and 15, he has found that this payment system has been deviated. Now, the change in the payment condition, your lordship may kindly see at least 71.
Page
71 of the report. The part of the LOA.
71. Okay. Yes.
A, supply, erection, testing, and commissioning of the work. So, my lord, we found below the note.
Just 1 minute. Yeah. Earlier was here, na? Page 36. Yes, note.
No, as per the project completion in all respects, date is 31/12/2021. Release of the installation of 50% progressive payment will be based on the physical progress of the work as on date. This connection is certificate of actual physical progress of the work from detailed projects in detail of concerned district that have to be submitted by the contractor. So, my lord, the change is, first of all, when I will land with all the equipment, 60% payment will be made immediately. Now they are saying that because of the problem of 80%.
Now, what is page 71? Page 71 is what? LOI.
Page 71 is a part of the LOA, my lord.
Where is the LOI?
Page 67.
Huh?
Page 67. LOA starts.
Page 67, letter of award.
Letter of award from the
terms and conditions of payment enclosed as Annexure A. So this is Annexure A. Huh? Okay, so this has been changed. Okay, then,
So there is a deviation in the payment condition. So I wrote a letter. That is by annexure 1975.
hmm,
Chief General Manager. Can I read it?
hmm,
With reference to the above subject, we Ganesh Electricals Private Limited are conditionally accepting the LOA offered for the works of the electrification works under so package number 4, 11, and 15 with regards to particularly allotment of quantity and allot us the total number of systems in a single technical amounts from the packages for we have received the LOA. As per our finance offer, we found to be lowest bidder. Against which we are in the receipt of the LOA of the works. So next page. We'd like to draw your kind attention. The rates quoted by us were by keeping with the detailed scope of work for number of solar HMS system as per the NIT. So for package number 4, 11, and 15. Further, as per detailed supply of work, it is not commercially viable to provide the CMC services in multiple districts for such stock quantity in each allocated district with the requisite technical personnel for the period of 5 years.
so this was not there earlier. This aspect was not there. It was not commercially viable to provide CMC.
Earlier, it was also not there for my humble submission by work, because we have applied for the
No, Mr.
number of packages.
No, Mr. Singh, kindly see, further, as per the detailed scope of work, it is not commercially viable to provide the CMC service in multiple districts for such short quantity in each allotted district with the requisite technical personnel for a period of 5 years.
Right.
Whether this was earlier there or not.
It was not there, madam, because the
No, show me.
yeah, I'm coming to that. May complete this one. Considering the mention above that we only request you to please and allot us the total number of system in a single package only. Amongst all the packages for we have received the allocation package number 4, 11, and 15. First priority, full quantity of package number 11, 476 instead of 1589 number of systems. Then second priority, full quantity of package of secondary package number 15. 4,000, we have applied for 4,000, 2,000 was granted by the and 4127 2093 numbers of systems.
And third priority was full quantity of fuel. Then,
Read another letter, madam. Next page, madam.
yes.
That is of 1911-2024.
Hmm.
In reference to the above subject.
So this has no reference to that annexure A. Obviously, it is not there.
Yes, sir.
So this has nothing to do with annexure A. Then,
In reference to the above next page.
hmm,
7, and 10. In reference to the above subject and LOA means when so are writing this letter to highlighting the changes in terms of payment of this standard as per the table. That as per the tender, then we can as per the tender NIT happened before. First installment was 60% given against the supply of various items of price schedule 1, including 100% basis that we paid on the receipt and acceptance of the material for substance of the calculation immediate value. Now, as per the annexure A of the LOA bylaw, it has been changed. There has been project completion in all respects. A is 31 towards 2021. Release of 60% of progressive payment for physical components of the work as on date.
okay, then,
Next page, we would like to inform that the in terms and conditions of the payment after allotment of works shall adversely affect the financial planning and execution of our project and that the project under the revised terms of payment.
so you want to revoke it.
Yes.
Then,
Then the letter from the next page, letter from the UPDC. Email my lord. First line. Page 79. With reference to the subject cited above, we should inform you that as per the terms and conditions of LOA, you have to confirm your unconditional acceptance of the LOA. Then I will be here written Latin. By annexure to your matter.
Okay, then
By annexure to your matter, register requested that there is changing terms and conditions of the payment.
so you ask for the EMD. Then
Then my this LO was terminated. And the immediate effect due to rejection of LOA and my EMD was forfeited. Please terminate.
so EMD has been already forfeited.
Already been forfeited. So thereafter we have written this letter to the Honorable Power Minister also, the order of Power Minister also kind enough to write a letter to the Managing Director ATDCL to our matter and to resolve the matter.
Those are inconsequential. But the question is, in the tender conditions, there was a terms and conditions were mentioned in Annexure A. This was changed out there while issuing the LOI. And this you are not agreeable. You are otherwise agreeable to do as per the NIT. So that is your case.
I must have been saying there is already one version of this.
Justice Manish Chaudhary.
That I am relying on. Facts are similar. This is minor with regard to 9, 10 and 11 electrical.
Lordship in 9, 10 and 11. Yes, there was change in the payment terms. But apart from that change in the terms, petitioner was also not agreeable. Petitioner was also not agreeable. 9, 10 and 11.
To the quantity.
To the quantity.
And that is another thing, but he has revoked it because of that. He in that page 75 or 76, he only wanted modification there on 15/11/2021. Then on 19/11/2021, he writes out there saying that we are not agreeable, for which you revoke it.
Yes.
They revoke it. They revoke the terms because of the terms being not same to what they have expressed. So there they have done this. Nothing to do with those other terms which have been given or not. Yes, as regards, if they don't accept it at that point of time, as regards the quantity, it's a different aspect of the matter. But as regards the other terms, can you change the terms thereafter?
We could have changed the term, but we could not have perhaps.
No, you cannot impose the
We
EMD.
could not have imposed. But otherwise, just for your lordship's consideration, the tender document mandated the unconditional acceptance of the tender has to be rendered within 7 days. Even if they had some grievance regarding the payment terms, regarding only the payment terms, then they were duty bound to convey before the next.
When was the LOI issued?
Was issued on the 12/11/2021.
So they have done it with on 19th,
That in 7 days will be 7 days will expire, then
on 19th,
if we include the 12, then perhaps
12, 13, 14.
that is just one aspect of it. But in item numbers 13 and 14.
That I have not come into.
Yes.
We are only on this.
These three are not checked. This is perhaps did not have proposed that change about the ownership to be honest. So these three
Needs to be set.
Yeah.
Thereby allowing them to get the EUR to refund the EM. These are all respect to 3 packages. So we, by one judgment, these 3 can be disposed of.
in fact the item number 14 can be put along with this.
This is 9.
9, 10, 11.
One judgment you can't do 14 because of the fact that 14 is a different party. Na?
Yes.
But here all communications are same on in this. But the goodness of Mr. BK Singh is that he has filed 3 requisitions. Unlike we find repetitions of 1,000 people in one. Let me first dispose of these three. Yeah. Mr. Pathak, yesterday only I could sign that order. My stenographer was ill and he was not there. Remember that order? Therefore, I say 45 days from the date of the certified copy. And in the meantime, I fix the amount or freeze the amount on 22/8/2023. That is the date of the order. And if you don't pay within 45 days, apart from action to be taken under for violation of the orders, you will be entitled to interest at the rate of 12%. The three repetitions are taken up for disposal by this common judgment and order. The facts, as could be seen on a perusal of the pleadings contained in the three writ petitions, which are interlinked and the parties being same, which are interlinked, are that the respondent company, that is the Assam Power Distribution Company Limited, for short the APDCL, invited bids from interested bidders for various projects on domestic competitive bidding basis against various packages. The three repetitions herein relates to package numbers
4, 11, and 15.
4, 11, and 15. For the purpose of getting a gist, for the purpose of giving a gist of the said packages in question, it is relevant to mention that package number 4 was in respect of Dibrugarh, Jorhat, Tinsukia, Kamrup, and the number of, what is HH? HH. Page 29. And the number of H's were 786, 117, 705, 2459 respectively. Households. And the number of households were 786, 117, 705, 2459 respectively. And the total requirement of systems was 4127. In respect to package number 4L, next to this. In respect to package number 11, it pertained to Borpeta district, where the household were 4768 and the requirement of the systems was 4768. In respect to package number 15, The district was Nalbari, and the total household, along with the requirement of the system, was 4,000. The said notice inviting bids contain various terms and conditions. It is for the purpose of the instant requisition. It is not required to refer to all such terms and conditions, save and except Appendix 1, which contains the terms and procedures of payments. A reading of the said Appendix 1, which was a part of the invitation of bids, and more particularly clause A, which relates to supply, erection, testing, and commissioning of the works. It stipulates that the first installment of 60% would be paid against supply of various items of price schedule 1 bracket complete items of individual solar home lighting system bracket close, including 100% GST, which shall be paid on receipt and acceptance of the materials on submission of documents indicated therein. Then there's a note in subclause 1 of clause A of Appendix 1, which stipulates that total 4 numbers of progressive bills against supply shall be allowed, comma, after submission of 2 numbers of supply bills, the contractor shall have to complete erection, testing, and commissioning of the 100% material / equipment supplied earlier for submission of the next bills against supply, and supply of 100% ordered quantity shall be completed as per the stipulated timeline mentioned in the LOA. The petitioner, on the basis of the said invitation of bids, submitted its tender for packages 4, 11, and 15. Did you for others also? No. You got for 4, 11, and 15. Did you for others also?
Yes.
Others also?
I bidded for 3,
For bidded for various packages, including package numbers 4, 11, and 15. On 12/11/2021, identical letters of acceptance were issued, letter of award was issued to the petitioners by the respondent company. in respect to packages 4, 11, and 15. In the said letters of acceptance awards, amongst others, the terms and procedure for payment were enclosed as Annexure A. The Annexure A, which is a part of the LOA, upon being perused, shows that in terms with clause 1.1, 60% of the payment shall be made against supply of various items, complete items of individual solar home lighting system bracket close, including 100% GST shall be paid on receipt and acceptance of materials on submission of various documents indicated therein. And the note appended to clause 1.1, subclause 1.1 of clause A of Annexure A stipulates that as the project completion bracket in all respects bracket close date was 31/12/2021, release of the installment of 60% progressive payment will be based on the physical progress of the work as on date. It was further mentioned that in that connection, a certificate of actual physical progress of the work from the AGM bracket projects, APDCL of the concerned district shall have to be submitted by the contractor. It was further mentioned that total 4 numbers of progressive bills against supply shall be allowed, subject to the condition as given. It further reveals from the records that immediately upon receipt of the LOA, the petitioner submitted a representation on 15/11/2021 in respect to the 3 packages, that is package number 4, 11, and 15. Requesting that the quantity for which the petitioner, the packages were, the quantity for which invitation of bids were made, be allowed to be supplied by the petitioner. Be it as it may, on 19/11/2021, the petitioner revoked the letter of award and withdrew the bid and sought release of the bank guarantee EMD on the ground that the LOA, insofar as Annexure A, the LOA, in as regards the terms and procedure for payment on the ground, that the terms and procedure for payment as mentioned in the invitation for bid, that is in Appendix 1, was different, which was agreed to by the petitioner while submitting its bid, was changed by the respondent company APDCL while issuing the letter of award, as could be seen from Annexure A of the letter of award. Under such circumstances, the petitioner therefore requested that the bid so submitted by the petitioner be deemed to be withdrawn and the EMD be returned to the petitioner. However, the respondent authorities, right? Dated. Right. Email dated 22/11/2021. No, not this. By the email dated 25/11/2021. Terminated the letter of award in relation to package number 4, 11, and 15 with immediate effect. Giving reasons that it was done for rejection of the LOA by the petitioner, and accordingly, and thereupon, invoke the bank guarantees which were submitted by the petitioners as EMD in respect to package number 4, 11, and 15 of rupees 25 lakhs each. The petitioner being agreed by the invocation of the bank guarantee and the realization of the amount of and the realization and by the invocation of the bank guarantee and the invocation of the bank guarantee and have approached this court by filing the 3 writ petitions. It reveals from the records that this court, by an order dated 17/3/2022, issued notice The record further reveals that the respondent APDCL had filed a detailed affidavit in opposition and invoke the bank guarantee and forfeited the amount of rupees 25 lakhs each against each of the 3 packages. I've heard the learned counsels for the parties and perused the materials on record. This code in detail have mentioned the terms and conditions, the terms and procedure of payment as mentioned in Appendix 1 of the invitation of bids. whereby 60% of the payment was to be made against supply of various items of the price schedule 1. Bracket, complete items of individual solar home lighting system, bracket close, including 100% GST. The petitioner duly agreed to the said terms and submitted the bid. However, while issuing the LOA, letter of award, dated 12/11/2022 or 21, 22, 21. Well, 11/2021. The respondent authorities, the respondent company, changed the terms and procedure of payment whereby the release of 60% was dependent upon the progressive payment. The release was dependent upon the progress on physical progress of the work as on that date. Now the question therefore arises as to whether the respondent APDCL could have changed unilaterally the said term said terms of payment when in the invitation of bids the terms of payments were different. The contract gets into. The invitation of bids, as was done by the respondent company, contained various terms and conditions calling upon the tenderers to submit, to supply on the basis of the said terms and conditions. This offer of the respondent company and more particularly this offer, which includes the mode of payment of the respondent company, which includes the mode of payment, was duly accepted by the petitioner by submitting his bid. This bid, which was a counter offer being this bid, which was an offer, the bid so submitted by the petitioner in respect to package number 4, 11, and 15, which was the offer of the petitioner, was duly accepted. But by changing the terms of the payment, the terms and the mode of payment, unilaterally by the respondent company, in the opinion of this court, the said letter of acceptance award would not have been imposed upon the petitioner by the respondent company by changing the terms which was agreed to by the petitioner pursuant to the invitation of the bids. The petitioner, therefore, for business reasons, revoked the letter of award issued in favor letters of award dated 12/11/2021 issued in favor of the petitioners. In respect to package number 4, 11, and 15. The respondent authorities, however, arbitrarily, the respondent authorities, as already stated here in above, the respondent authorities could not have unilaterally changed and imposed the conditions as enumerated out there in Annexure A to the letters of award. But strangely, but are most arbitrarily and unreasonably invoke the bank guarantees which were submitted by the petitioner as earnest money deposit in respect to all the three packages, and thereby forfeited the amount of rupees 25 lakhs each in respect to the three packages. This action on the part of the respondent company, in the opinion of this court, not only smacks of arbitrariness, unreasonableness, but also irrationality, and accordingly violates the mandate of Article 14 of the Constitution. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. Number one, the invocation of the bank guarantee bearing number, a number page 80 BG number 8 page 80 aku ada bank guarantee number itu, aku ada bank guarantee number 18. In relation to package number 4, 11, and 15, respectively, of an amount of rupees 25 lakhs each by the respondent company, is in violation of Article 14 of the Constitution, and accordingly, it is declared that the said actions are illegal, arbitrary, unreasonable, as well as irrational. Number two, the respondent company is directed to refund the amount of rupees 25 lakhs each in respect to the bank guarantees bearing in respect to 25 lakhs each. The amount of rupees 75. Let us make it 75 lakhs. The amount of rupees 75 lakhs, which was illegally forfeited by the respondent company to the petitioners within a period of how much? Within a period of 20 days from the date of submission of a certified copy of the incident judgment. Anything else? Done? Now, what is the other one? Same. Same.
No, that is 14.
Same condition. Huh? Number will change. Okay, it is silent. It will 14 to 40. What are the other two matters? It is 14 to which access to 12 and 13. 14 to 14 disposed.
The actual difference here is there is the invitation to offer, and when we have very submits of data, the party submits of that is the offer. Please accept it as it is your object. That is about to accept. Now, once we make some changes in the letter award, that is the amount of counter offer. Once that counter offer is accepted, your object, that means the contract is complete.
So it is something like that. That case where you give a counter offer,
Yes.
that we are going to say in annexure A,
Yes.
being in annexure A, this is your offer,
Yes.
and they accept that annexure A, then the matter is closed.
In this case, they have accepted it. They have said yes, we accept. But after accepting it, and after acceptance is complete as against us, then they want to resign from their acceptance and no.
Then did you issue, once they accept it, means they accepted it. They accepted the tender,
They accepted
conditionally.
the change condition of,
The change condition they've accepted. Then they wanted to revoke.
then they want.
They were issued a letter, they had deputies for the 11, they have accepted. They are after within 3 days, when they realize that the 60% that change in the terms and conditions, that again, they have also written that and return my bid and my PNB may be PNB may be
How do you do that?
now the respondent condensate, I think is that this is a concluded one. In my humble service, it is not a concluded one as my lord. Because after the strength of the
It is not a concluded contract, means there is an offer and acceptance. They have given you an offer. You have accepted it. And thereafter they are going to issue the contract. The moment the offer and acceptance happens, the contract is done. Doing that.
I have written thereafter, they have again written to us, they kindly accept it under unconditional.
Huh?
They have again written to us by their email that kindly accept it in tender unconditional.
Then
And again, I have said no because of the change of the terms and condition.
no, didn't you accept it earlier?
Earlier, I have accepted
Then
my after submission, my lord. Then I will just rely on one paragraph of the ordinate, my lord, my lord. Paragraph 21.4, my lord.
what does it say? No, tell me. Yes.
Whether the issue whether a conclusion at the party, it also depends upon the terms and conditions of the NIT, and the tender document, the letter of award issued by the employer in the favor of the petitioner and successful bidder and the conduct of the party. The letter of award was issued stating that the LOA was issued to the petitioner for the package number 3 as per the rates, specifications, instructions, and the terms and the conditions of the stipulated LOA. The LOA mentioning total contract price by appending the note to the LOA wherein the terms and conditions were set forth by the Annexure A and Annexure 4 to the respondent indicating that the on unconditional acceptance within 3 days, date of issuance of the LOA, the petitioner would be required to subcontract performance guarantee for 3% of the contract price within 7 days from the date of issuance of the LOA. The LOA further contained that in the event of the non-partition of the PPT within the stipulated period, the award might be terminated and the bid security would be forfeited without any further notice. The LOA contained the condition that if TEC would be stand 45 if the contractor was not able to complete the awarded work of the employer within the scope of the work and also within the stipulated time frame. The reading of LOA indicates that in the event of successful bidder did not accept the LOA unconditionally stipulated time period, the award notified by the LOA will be terminated by the bid security submitted by the successful bidder which be forfeited without any further notice. On the other hand, if the successful bidder had accepted the LOA unconditionally, submitted the PBD and signed the contract with the APDC within the stipulated period of the date of award, successful bidder would become the contractor. Okay, after execution of the contract agreement, the contract would fail to execute the awarded contract work as per the terms and conditions of the contract agreement of PBD. The contractor could.
Mr. Saying, why do we have to go to so much? Why do we need that? See section 7 of the Contract Act.
Actually and unqualified. He expressed in some legal and reasonable manner. Otherwise, the proposal prescribes the manner in which it is to be accepted. If the proposal describes a manner in which it fails to do the accepting sector.
It's simple. Why do you need a 48-page judgment? You have given, you see, the promise which was made by them, the proposal which you has given. In fact, what this case, it reminds me of that judgment of Carlin versus Carbolic. Have you read that? The very short judgment of the House of Lords. Beautiful judgment. So, this is an invitation of an offer or a bid. It's like a proposal. They are coming up and saying that, look here, we want to do this. These are the terms and conditions, whether you agree to it. You said, yes, I agree to this. Then they come up and say that, no, we want further change in that terms. This is my term. You agree there. There you did not agree. You agree here. But the contract is complete on the basis.
But again, they have written to us with the petitioner that please accept the tender unconditionally. After again, when I execute that law, because of these changes, I would like to withdraw my tenders. Or the petitioner again, within that.
No, did you not accept it
And
unconditionally?
because instead I accepted it immediately out of accept.
Then why did they write that?
But after accepting it, you wanted to resign from your stand.
No. Why did you accept? Ask him to, again, when he has accepted it, why did you ask him for unconditional acceptance?
Yes, because once accepted, at that point, once he's accepted, contract was complete. But after accepting it, he wanted to resign from his stand. At that point, he said, "No, my view is tender." There was a but regardless of the communication, the position of law is that once the acceptance is complete,
Contract is done.
whatever happens
Parties
after that,
add retail minority.
Have you stated that you did not? Let us see that document.
the document is at page number 72.
Which repetition?
WPC 1191.
1191.
Item number 12.
Page
Page
72.
72. We thank you very much for the aforementioned. Yeah, we pleased to accept your order and look forward to doing business with you. Thank you. So,
Auto accept.
as an acceptance, you accepted it. Now you can't go back. Oh, there, Ganesh Electricals or Premier got something. Why should I?
Can I also see my page 75 year letter?
You must have given some cyclostyle thing. Yeah. Yes.
With reference to the subject about this is informed that as per the terms and conditions of LOA, swift people you have to confirm your unconditional acceptance. Therefore, you are requested to confirm your unconditional acceptance to LOA within 2 days. Then after I have written no, like.
So this is the responsible letter at page number 72.
Whatever it is, but it is
Okay,
after my letter dated 18/11/2024. Then the email dated 22/11/2024. My humble submission is that contract is not concluded because the parties are not at detail.
Huh? Parties are not.
At detail, my consent not there with the party.
This document shows that it is there.
After I say because after coming to the that change in the division.
Now, is there an arbitration clause, Mr. Patel?
there is an arbitration.
Fantastic. There, here I don't find any arbitrariness. You go to the arbitration. I think, Mr. Singh, that is the only way. This
Can
court-
it be taken about some other thing?
Okay, but this is the only way where it can be done, because otherwise, why should I? Because I don't find this to be in violation or arbitrary when this document is there. Now, the question will be on the question of interpretation of the terms of the contracts. In those matters, what they have done, they have unilaterally changed the terms. Here, although here also they have done it, but you have accepted it. Now, whether that acceptance would be an acceptance for the purpose of the formation of a contract, this court under 226 starts. Arbitration. You didn't ask when the other matter was there. Chalo, anyways, let him have also the luck with some other things. With judgment.
That is Karnataka law official cooperation versus serious.
For what?
Nothing is completed contract.
What does he say? As the Contract Act 1972 has been changed, still remains section 7. It doesn't matter. So it doesn't. Leave the matters well and keep this. It may require if it goes before any other bench. 20, 21. Today's what? No. We'll have it after Puja. The learned counsel appearing on behalf of the petitioner submits 6 for an accommodation for which the matter stands adjourned to be listed after the Puja recess. এটা matter এটা আছিল লাষ্টত লৈছিলে what is that item last item to be this is the last item today. Somebody mentioned that matter for upgrading. Where is that? 29. To say one item. Yes, any urgent matters? Any urgent matter? Oh, your matter is there. Yes. Yes, let us take up 29 then. I promise her we'll try our luck. Others may go. 59. Who? Oh, this matter. That is the central excise. No. This can't happen, madam. Here is there's a big problem with this matter now. We require the industries department. Industries department has to be there. We'll have it some other day then. It's the matter after the after 4 weeks. After 3 weeks. Huh? Yes. Why? Why? Is it urgent?
For me, it's not urgent. I'm running this.
Then let it remain. What is that? 2021 matter. Who is it? What is this? Running a shop?
No, that Guwahati railway station.
Ooh, that one. Platform number 2.
Yes.
I have directed some filing of something.
Yes, they're fine.
Who has filed? It has Mr. T.H. Hazarika, the learned counsel appearing on behalf of the petitioner, expresses urgency in the matter. He further submits that the railways have today filed an affidavit for which he would like to go through the same. List the matter again on 28 September. 27 is Wednesday. 26. Yes, Mr. Agarwal, we don't see you nowadays.
LCR reminder, LCR not come. So reminder mechanism is
No, there's no urgency in these matters.
LCR only reminder for LCR.
Why should I give reminders? Go before the authorities, these people, why should I go? The registry knows what to do. Why should I pass an order to them? Huh? What is that case?
That matter, my lord, when I was placed under the police custody, despite being a juvenile. If I did go of the list, your lordship remembers, my lord, there was some amount of headache from the last 3 years. And
I referred to about the other matter, no?
Yes, no, it was in the top of the list.
Huh?
Last time it was in the top of the list.
Then now it has gone to the bottom of the list.
Because of LCR lordship.
LCA has not come.
No.
Okay, good luck. The Panchayat Jackson 2017. Yes, Mr. Roy Chaudhary. Yes, what is it? Why? What is the urgency? Demarcation, simple matter. The demarcation.
Consensus order can be passed.
Okay, leave the matter after 25th. 23 and 24 we listed after in the first week of October. Yes, 19 and 20, Mr. R. Dubey. Yes, what have you done?
But I have not done, but railways have done matter.
Yes, that day, yesterday I was taking up one matter, you were not present, State Election Commission.
Yes. Madam.
Why have you not done that? Having Jila Parishad election and no, you are not filing an affidavit? I've asked them, otherwise the CEO has to be personally present. Yes, tell me. Let me see your file, wait. Yes. Yes, Mr. Dubey.
Regarding number 26, my.
No, wait, let me, yes.
The calls have been tendered, mother. Where the petitioner has approved right in terms of their mother, in terms of the agreement.
Then what do you want?
Or bid for hearing.
Hearing?
So then, the fact the railways have filed an application saying whether.
Why the matter has been fixed on Tuesday? Why?
Directed.
I have directed.
Dispose of the matter.
I have directed today.
Last opinion it has come.
Then I must have heard this matter. Have I heard it?
At some length, because here the railways file an application saying that they are not necessary parties in the Union of India.
Oh, yes. No, not the railway. The Ministry of Railway has nothing to do. This is as regard the tender matter.
Yes, sir.
I remember. You have challenged some tender and you have made the Ministry of Railways also a party.
Yes.
And more particularly to the secretary. They have filed an IA for that, removing the secretary.
Yes,
Yeah. 1920. Have it on 5th of October.
Yeah, keep some matters. Keep some other matters.
10th of October.
Yes. And there is an interim one.
Interim order passed earlier. Hey, tu Pale. Agarwal sir. 7. Yes. Upon hearing the learned counsel, the story of the bill for deciding the dispute involving the Presently pending inquiry. Why is this original case sought for?
Because my lord, there was some sort of manipulation in the forwarding, because the age of the criminal was shown to be 18.
Oh, that
That
one.
man.
Yes. You are appearing for?
And actually, amicus
And who? And you?
petition.
Amicus. When were you appointed, Mr. Burwa?
My lord, there's an order, my lord. I was appointed, my lord, on,
Oh, yes. 23/6.
correct.
So amicus হিসাবে দেখাবো দেই? No. কোনটা চাও? কোনটা? এগুলো তো amicus হিসাবে দেখাবো না, advocate হিসাবে amicus, হ্যাঁ? The office note dated 12/9 this court have duly perused the order dated 8/8/2023, as well as the office note dated 12/9/2023, which shows that the original case record of GR case number 313/2014, which is in relation to Manja PS case number 25/2014, pending before the court of the additional chief judicial magistrate Tipu Karbi Anglong, has not yet been received. The registry is directed to forthwith take appropriate steps so that the said records are received at the earliest and more particular the earliest and on the is received by the next date so fixed. List the matter again on 12th of October.
All right, give you.
Amicus naam to diyo de. Yes.
Item number 25. 2013, because my lord, the EPP was died inside the jail. My lord, on the last occasion, your lordship was pleased to produce the of an advocate to the forensic report. So it's a piece of poison.
Then
It's an agent that they have filed one affidavit also.
then affidavit has not come on record.
The affidavit was done.
What is your stand? You are a petitioner. Come there. Yes, I want to record. This matter needs urgent 25.
They are applied for certificate to the hospital as well as that whole record was sent
To the
to the district magistrate.
when? Will you file to the host? Yes, I remember that UPP matter. I have passed some directions here. Is the matter on which state shall apprise and bring on record the inquiry report of the executive magistrate as well as whether there was any forensic examination report pursuant to that postmortem report, wherein it says certain aspects. And what was there any forensic report?
My lord, that is yet to be sent. I have annexed that communication, my lord. Another thing that.
Accordingly, we requested the district magistrate to provide a forensic examination in respect of so and so. The same was not traced out till date, and it will be submitted to you as soon as the report is received from the DC's office. In this connection, I would like to inform that the superintendent is also requested to provide a certified copy of the IMAN in respect of the deceased so and so to the undersigned for onward submission to the Honorable High Court on so and so. What is this inquiry report says? Does the inquiry report, which was done on 31/7/2012, when did the person die?
31/7/2012.
Huh? Oh, okay. When was the inquiry report dated?
6/8/2012.
Oh, okay, immediately. So then at that point of time, the forensic report was not there because the postmortem must have happened. Where is it mentioned? Because this report, it becomes useless then. After completion of the postmortem, the body of Ia was handed over to the family members. Observing all the facts given in so and so, Dr. Rajiv Pukan, the inquest report of postmortem finding report, my view is that the Ia was suddenly died on so and so. And the cause of death may be due to heart failure, but the final cause of death can be known after receiving the forensic. So this report is also useless. Now, if that is so, let us see what you have stated. That is a very relevant thing because you said the inquiry has been done. Where is it? Eviction. What is this DNA business?
My lord, if this is, some indication was made against the general mother by the second one regarding any issue. That is why he was in other time, after that.
But what has happened, my lord? Case, my lord, it was registered in
No, here is a case where directing the authorities to conduct a judicial inquiry or an inquiry by impartial agency to the entire case so that the actual truth will be unearthed and the responsibility could be fixed on the person for whose negligence the petitioner's son died prematurely without any treatment and impose adequate penalty on the persons concerned. So this is what he is being asking for. Now here the petitioner's son was found to be fit, medically fit. Copy that they are so and so, the report for seeking how the concocted story has visited the jail and so and so. While denying the Syrian member was sent to out of the jail at demand for production to the Iman and after being finished. It appears that they have the scrutiny done within 24 hours, which forms a part of the incident, forming the occurrence of the online changes in internet. It's evident. The word incident is does not refer to the occurrence of death. Meaning that the cause of death was synoptism probably and Iman and Iman. Yeah, I'm saying that the event. So that report, this, if you have based your entire case on the basis of this inquiry report, it becomes useless because your entire report is big bogus. It's inconclusive. What inquiry? Why haven't you followed up thereafter? Eh? Yes, madam. Why haven't you followed it up?
They have even submitted, if the ED case was registered, and ED case submitted in filing report.
So now there is no forensic examination report.
That is, submitted to district magistrate, my lord.
Where?
Around 65.
It is informed that by, huh?
Second,
This has been done now. In this connection, I'd like to inform that the officer in charge was requested to submit the forensic report dated so and the so and so that all the relevant documents of previous along with the file has been submitted.
Yes, that this is my.
Alone. all the relevant documents of UD case number along with the final report has been submitted to the additional remand. Accordingly, we requested them to provide a copy of the forensic in respect of so and so. As soon as we receive the said report, we will. This is only an instruction. This is no business. In fact, I tell you, they have not done the forensic. Who are the people involved? We have to bring them to justice. Okay. The record for the reveal, it reveals that pursuant to the order dated 7/9/2023, an affidavit has been filed by the Inspector General of Prisons, Assam. By whom? No, by the Deputy Inspector General of Prisons, Assam. The forensic examination report, the reference of which has been made in the postmortem report, the forensic examination report, which was directed to be done in the postmortem report, however, has not been produced. Ms. M. Bormon, appearing on the learned junior government advocate, seeks for an accommodation. As there is a move, as the respondent authorities are taking every steps for the purpose of obtaining, for the purpose of tracing out the said forensic examination report. Okay. List the matter again on 10th of October 2023. On the said date, Ms. M. Borman, the learned junior government advocate, is directed to ensure that the forensic examination report of the victim is produced before this court, failing which this court shall presume that there is no forensic examination report and consequently draw appropriate presumption. List accordingly. Yes, Mr. Kolita, what are you doing? It will go after puja.
Itu sama mudah dia.